you. Good afternoon. My name is Richard Gabbert, and I'm the Chief of Staff of the Crypto Task Force. Welcome to the first of a series of roundtables in the Securities and Exchange Commission's spring sprint toward crypto clarity, how we got here and how we get out defining security status. Constructive engagement between the Commission and the public on issues related to crypto has been a long time coming. But over the past several weeks, the Crypto Task Force has been meeting with market participants and has received considerable written input as well. These conversations and materials have been extraordinarily helpful, and we hope that market participants and members of the public will continue to request meetings and make written submissions. But we're also excited to begin this next stage of our own ongoing engagement with the public in a format that invites more parties to engage with each other in an open discussion of key issues in this space. Given the range of views held by today's participants, we expect the conversation to be lively, provocative, and productive. Our hope is that the cumulative result of this engagement will be to enable the task force to help the Commission develop the regulatory framework for crypto in a way that promotes innovation while protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation. Before I turn the podium over to our three commissioners, I would like to remind everyone that this event is being streamed live and is being covered by multiple media outlets. Accordingly, please be aware that all remarks by Commission officials, participants, and members of our audience will be on the record. In addition, please remember that the participants in today's roundtable speak on their own behalf and that their views do not necessarily reflect the views of the Commission, the Commissioners, or members of the Commission staff. With that, I would like to ask our acting chairman, Mark Ueda, followed by Commissioner Crenshaw and Commissioner Peirce, who will each offer some thoughts to set the stage for this afternoon's conversation. Mr. Chairman.
Well, thank you so much for that, Richard. And good afternoon, and welcome to the Crypto Task Force's inaugural roundtable, which will explore the complex legal issues involved in classifying crypto assets under the federal securities laws. But first, I really want to thank all of our panelists today and all of you in the audience for taking time out of what is a lovely day here in Washington, D.C. to be with us today. And particularly with this panel, I've had the privilege of knowing many of the panelists for, if not years, decades, and have looked at their writings and their thoughts. And I'm really pleased that we have such a diverse set of perspectives that you'll hear from today. In the wake of the 2008 financial crisis, a group or a person going by the name of Satoshi Nakamoto released a white paper describing a new peer-to-peer electronic cash system called Bitcoin that helped form an entirely new digitally native asset class. 17 years later, market participants, lawyers, academics, policymakers, and regulators are still grappling with critical questions related to the status of these novel crypto assets under the federal securities laws. This disagreement is most pronounced when it comes to the application of the investment contract test established by the Supreme Court in its 1946 decision in SEC versus W.J. Howey Company with respect to crypto assets. The challenges in applying Howey's investment contract test, though, are not unique to crypto. In fact, I've got a little bit of firsthand experience with it. As Chief Advisor to the California Corporations Commissioner, I stood before a California Court of Appeal and argued that the offering of a non-security certificate of deposit, when packaged with a separate receipt of a bonus payment, constituted an investment contract. Although the state court concluded that it was not, other federal appellate courts had held that similar arrangements do satisfy the Howey test. Now, in the years following Howey, various courts of appeals are split on various nuances and other aspects of that decision. For example, does Howey require the pooling of investor funds and pro rata distribution of profits? Or is it sufficient that investors need only share the risks with the promoter? In some circuits, the fortunes of all investors must depend on the promoter's expertise, but in other circuits, the fortunes of the investor must be interwoven with and dependent upon the efforts and success of those seeking the investment or of third parties. Similarly, the courts of appeal are divided as to whether an investment contract requires post-sale efforts by the promoter, or if significant pre-purchase managerial activities undertaken to ensure the success of the investment suffices. Now, differences in opinions among various courts is not unusual. After all, a judicial opinion is limited to the particular facts and circumstances of that case. When judicial opinions have created uncertainty for market participants in the past, the Commission and its staff have stepped in to provide guidance. For example, the Commission clarified the meaning of an investment advisor's fiduciary duty under Section 206 of the Advisors Act in response to industry demand. The Commission also opined on the application of Howey to the offer and sale of whiskey warehouse receipts and condominiums, among other things. This approach of using notice and comment rulemaking or explaining the Commission's thought process through releases rather than enforcement actions should have been considered for classifying crypto assets under the federal securities laws. Today's roundtable is an important first step in addressing that concern. So thank you again to the many members of our staff who are on the Crypto Task Force, as well as our panelists and our participants and the interested public for your time in preparing for this roundtable, and I look forward to the discussions that follow.
Good afternoon. Thank you all for being here today. Appreciate all the panelists' time. Appreciate you all being here. I anticipate the discussion today around two big questions. One, are crypto assets securities subject to SEC jurisdiction under existing law? And two, should they be? Enhancing regulatory clarity is a laudable goal. So is a reasoned policy debate. As long as our goal is to promote compliance with, and not avoidance of, a legal framework that is faithful to the SEC's mission to protect investors and the markets. As we delve into today's topics, we must bear in mind that the stakes could not be higher. You will be discussing the legal underpinnings of the $120 trillion U.S. capital markets, which remain the envy of the world. The financial well-being of tens of millions of Americans and countless American businesses depends on consistent and effective regulation of our markets. This regulation rests on a well-built edifice of law that, over the last 90-some years, has been duly built up by Congress and the courts. At the foundation of that structure is the definition of security. And the Commission has used this definition for decades to successfully regulate an incredibly diverse array of financial products. We cannot poke holes in the foundation without expecting the walls may crack. Modifying the law to facilitate the success of a chosen product category is fraught with risk. Risk not only of weakening regulatory protections for that category, but of creating a negative domino effect on other areas of the market protected by the same laws. For the SEC, holistic protection of the markets has always been and must remain our North Star. That said, I understand there's a view that current law is not working for crypto. And I agree that policy must keep pace with new products and technologies. I welcome the diversity of views and urge you to present those views with careful consideration of the potential benefits and costs of proposed actions. This means asking, for example, what authority does the Commission have to make such changes? How do you balance the desire for greater clarity with the need for a sufficiently flexible definition of security that cannot be easily evaded? Does the contemplated change protect investors, the capital markets, and national security? This is critical given the heightened risks associated with crypto assets, including, just to name a few, their speculative nature, a disproportionately high volume of scams and frauds, lack of legal redress available against bad actors that are unidentifiable or located abroad, and use of crypto assets to finance crime and terrorism. If the intention is to create a special rule for crypto assets, how can those assets, either as a group or by specific type, be clearly defined and differentiated from other types of assets to which those rules are not intended to apply? Will any new legal framework for crypto assets deliver a similar level of investor and market protections to that of other similar asset classes? Will it provide a level playing field among all market participants? I look forward to hearing a variety of viewpoints today on these and other issues. Thank you for the Crypto Task Force for organizing this event, and thank you again to all the participation and your engagement with the Commission.
We're about to get this show on the road, so don't worry. I'm not going to talk too long, but thank you to Richard, to Chairman Ueda, Commissioner Crenshaw, and thank you to all the panelists for taking your time to be here today and bring us your expertise, and thanks to those of you in the audience here and watching online. I'm delighted to welcome everyone today to the inaugural roundtable of the spring sprint toward crypto clarity, which is actually quite hard to say, but it's actually harder to do, so we're going to see that later. Thank you to our panelists. You do bring years of experience and serious consideration of the topic at hand to the table, and I think as Chairman Ueda and Commissioner Crenshaw laid out, we're approaching these issues in the context of well-developed securities laws, and we are working with those laws to try to get to a place where people can easily and consistently apply them in the crypto context. It's fitting that today's panel takes place exactly 2 months after Acting Chairman Ueda announced the formation of the Crypto Task Force. And just as DC is brimming full of the early signs of spring, spring signifies new beginnings, and we have a new beginning here, a restart of the Commission's approach to crypto regulation. The formation of the Crypto Task Force gave permission to staff working in the building to seek earnestly to find a workable framework for crypto regulation, and staff have responded with palpable enthusiasm. I think there's enthusiasm in the room here as well, so let's seize the moment and have a meaningful conversation today. I think there are lots of people in this room who have been thinking about these issues for a very long time on the panel, in the audience, so I think we're ready for the sprint ahead. The roundtable series that we're starting today will allow us to explore issues collaboratively. I'm reminded of a story that my brother told me recently about how he had a shed on his property that was really in great repair, and he was going to pull it down, and a friend of his came over who was very handy, and so he brought his friend back and said, hey, shouldn't I just pull this thing down? And his friend said, pull it down? Are you kidding? Let's build it. And he said, well, okay, we can rebuild it, but my tractor is broken, and we're going to need that. And his friend said, well, let's repair the tractor. So that day, they not only repaired the tractor, but they also put the shed up and got it shored up so that it was functioning again. And so I think that is a little bit of a model for what we're going to do today, which is we have to get the tractor running. We have to address those definitional questions, which are so key to so many of the other questions in this area. And they will allow us to then build a functional and efficient shed, which is the regulatory framework. And I think these people are as adept as my brother and his friend, so I'm excited to see what lies ahead. We do have some foundational questions I think that we can talk about today. Obviously, what makes something a security? Is that status permanent, or might an asset start as a security and convert to a non-security, or vice versa? How does decentralization affect our analysis, if at all? Can we translate the characteristics of a security into a simple taxonomy that will cover the many different types of crypto assets that exist today and may exist in the future? So thank you to everyone who made the roundtable possible today. There's been a lot of work that's gone into it by people throughout the building. I'm looking forward to the conversation. And I'm going to hand it over to our former Commissioner, Troy Paredes, who's going to moderate this group. And I'm really looking forward to the discussion. Thank you so much.
Thank you. Thank the entirety of the Commission for not only hosting this, but certainly for the opportunity afforded me to moderate. I'm looking forward to a lively and engaging conversation, and it's certainly great to be back at the Commission. The panelists have lots of different views, and I think that's what makes for a great panel. And if everybody was of the same view, we probably wouldn't need to be here, and the Commission wouldn't have seen fit to host all of us today. So it should be a great conversation. The goal, very much consistent with what's already been said, but just to offer a particular take on it, is a very simple starting point from at least my perspective, which is everything is something. And it may be a security, but it may not be a security. And so as I've often thought about it, this what is it question, or perhaps more aptly put, what are they question, has never been, I think, more front and center in the history of the federal securities laws, at least not insofar as I can consider or recall. I've taught Howie many times back in my law professor days, and I used to teach it out of almost a sense of obligation. And then all of a sudden, wow, it's one of the most important cases in the history of Supreme Court jurisprudence involving the federal securities laws. So it really is amazing to see how things have continued to develop in the context of securities regulation and otherwise, and that's no small part because of what the pace and magnitude of innovation has been over the last handful of years. So as was mentioned, the focus today is on what's security, how do you define it, and what does that mean particularly in the context of crypto assets, sometimes called tokens or digital assets. I'm sure we'll use those words interchangeably. Before we jump in, let me walk through some game plan so that everybody is on the same page. I'll run through a number of items. I'll do this quickly, and then we will get into the substance. So here's the game plan. I'm going to call on people. The first three, though, and I've not told them this yet, but they're about to hear. So the first three, so no one's caught off guard, are going to be Chris, and then Teresa, and then Sarah, and then we'll proceed from there. Next, in the initial go-around, I'd ask that you keep your responses to a couple of minutes or so. There is so much for us to get into, and the conversation is sure to be engaging and interesting, so we want to make sure we have plenty of time for you all to engage with one another. When responding, just your name and affiliation. Your bios are available on the Commission's webpage, extraordinarily impressive bios. So if you can just give your name, your affiliation, and encourage folks to take a look at the more complete bios that are available. Please keep it engaging and interactive. Feel free to react to folks, respond to folks, riff off what somebody else has said. If you need to get my attention, my, I guess, ask is lean forward, wave your hand, stand up, whatever it is, and get my attention. You can also, pipe up, and everybody will do that in a respectful way, I'm sure. If I interrupt, it's only so we have plenty of opportunity to hear from everybody. I hope I don't have to interrupt, but I won't be shy if I need to make sure we hear what everybody has to say. I would ask also that folks be as precise as they can be and define their terms. One of the things that I personally find challenging is there are so many new words or different words. Sometimes folks use the same word to mean different things. Sometimes folks use different words to mean the same thing. So I think if everybody understands precisely what it is that you're referring to when you use a particular phrase or a term, I think that'll help motivate the conversation as well. In addition to saying what you think, I would encourage everybody to say why you think it. I think that's a key part as well to make sure the conversation flows. A few final quick game plan points. I'd ask that you don't make any specific reference or even innuendo, if you will, to actual enforcement actions. And so keep it general if you're talking about anything that touches on something that might be related in some way or another to enforcement. Commissioner Peirce and the members of the task force, if there's something you want me to do, feel free to come up here and tell me to do it. I'm happy to take instruction. This is really about a discussion that's most useful for all of you, and so feel free to pass me a note or raise your hand or whatever, and chime in any way that's helpful. I think we go for about an hour and a half, and think until 3 East Coast time. So we'll keep to that. Then we'll have a break, and then after the break, my understanding is that there will be questions that folks have submitted from the audience, whether it's folks here who are joining in person. I think there's a way to submit written questions, and I think for folks who may be watching and joining us online, my understanding is if you were to email, and Samira or somebody will tell me if I'm wrong on this, crypto@sec.gov, then and if you put in the subject line roundtable question, then we'll be able to take those into consideration as well, and we'll work through those during the break, at least some of us will, and then be ready for after the break. Final point is there is more to it than Howie. Howie gets a lot of the attention, and for understandable reason, but there's more to it than that. And so certainly encourage folks not to feel as though this is only a discussion about Howie. It's a broader discussion by nature, even though Howie is certainly a key part of it. So with that, let me turn, as I indicated, to Chris. So Chris, you have a unique perspective being a professor as well as the CEO of a company, as well as the opportunity to sit on a few different boards. What are 1 or 2 considerations that you think should drive the determination as to whether a particular crypto asset is or is not a security? And to what extent, as somebody yourself who's thought a lot about disclosure that's related, how has your thinking about what's the most relevant disclosure when it comes to crypto assets or different kinds of crypto assets informed your assessment?
So thank you for that. My name is Chris Brummer. I'm a professor over at Georgetown Law. I am the CEO of Blueprint, a crypto disclosure company, and I am the former good friend of Troy for making me go first. So
I think we're still good friends, no?
Okay. Let me just go for a little bit of a running start, because it's important that this kind of conversation is difficult because we're all, on the one hand, a little bit of philosophers because we're talking about the nature of securities law, but we're also auto mechanics, which I take as our objective to come up with some actionable road items. When I think about putting on the philosopher hat for 15, 20 seconds, when I think about the Howey test just in general, because that is sort of this over-encompassing standard, it's a lot smarter than people would think. Certainly there are some limitations when it comes to crypto assets, but the logic behind it is actually pretty interesting when you think about each of the individual prongs. Ultimately, each of those prongs represents a kind of a risk that the gods of securities law have said when they are collectively there, we're going to mandate disclosure, as Troy had mentioned. We're basically saying when you have savings, there's an issue of investor protection. The common enterprise prong that we're all familiar with is really addressing a kind of free riding problem, almost like when you teach to a large room of students and you ask them to raise their hand and nobody raises their hand. Everyone's being a very rational actor. And so it goes to this question of whether or not there's going to be an under-provisioning of information. The efforts of others prong, it really just goes to information asymmetries. And then the question of sort of profits goes to investor psychology, greed and fear, the kinds of things that can distort decision making. And basically, when you have all those factors together, you have a mandated disclosure requirement. Now, many of those factors, I would say, are this is a very old rule. This is right after the New Deal, and it's premised on pieces of paper. And the kinds of risks that accompany transactions when information was distributed through pieces of paper. when you move to any kind of new technology, we're obviously talking about crypto now, but certainly a digital technology, the underlying risks relating to each of those prongs can change in different and interesting ways. And so when you ask me what am I actually, or what do I think a securities law regime or any kind of regime for crypto assets should look like, it should certainly address the fundamental sort of risks that would involve any kind of transaction when you have a collectivity of these underlying concerns, but it also has to address the changes of the technology, the backdrop behind which the transactions themselves are being consummated. This is not just a question of whether or not the regime is efficient for the market, but it's also how do you best protect investors. And I think that the two sort of key characteristics are what are the specific risks? I'm going to break it down to three. What are the particular risks? Are those risks reflecting this sort of old 90-year-old regime in terms of the sort of meta concerns? And then are there things that are interesting about the technology that require adaptation to those risks? Questions like predictability, which has not always been Howey's strongest point, become more important when you're dealing with a technology like this because you're talking about digital information, information that can be programmed, information that can be embedded in different kinds of transactional systems, information that can be used to comply faster, easier, more effectively. So what does that mean in terms of our analysis? In terms of the overall reach, last little bit and point, securities have always, I have a job as a securities law professor because I can give exams where things don't fit neatly into a category of securities law. That's you guys may take that job away now. But ultimately, it's in that gray zone that there's always been some kind of ambiguity, but does the ambiguity sort of rise to a level where you can no longer sort of build things? And when it does, you have to do a little bit of an assessment about what are the risks, what are the opportunities, we already heard that before, and then to think creatively and to build systems like you have iteratively to deal with those. So I'm looking to see that in a particular regulatory system, and there are many ways in which an auto mechanic can get this done, but they have different kinds of trade-offs, and I'm sure we'll talk about those trade-offs over the course of the semester/session.
Thanks, Chris. Teresa, so you have the perspective of being in private practice and doing enforcement-related work as well as transactional related work. And as I understand it, you focused a lot in your thinking on the topic we're talking about today around things like rights, duties, other characteristics and attributes that attend to a particular crypto asset or some arrangement, think about it from an investment contract perspective or otherwise. So can you expound upon that aspect and the ways in which right, duties, characteristics, features, whichever word or words you think are the best to use, are informative to the determination as to whether or not there is or is not a security? And how does that align? Does it align, or is it a different approach and perspective from what Chris was saying in terms of starting with the risks, right? As I understood Chris's point was you got to start with the risk and do some version of a risk mapping. Not that that's the only thing you do, but that that's an important piece of the overall assessment. How does your perspective align with that, or is it a different take on the question?
Oh, thanks so much. And I'm Teresa Goody-Guillen, a partner at Baker Hostetler. So I agree with Chris in that I think that risk mapping is an important part of the analysis. My analysis starts at a different place, and it's a much more fundamental level. And looking at it, and I don't want to get hung up like on too many words with, what is a right or an interest. I am using Black's Law Dictionary definition if anybody wants to know what I'm referring to, which is very broad. But in looking at this, what are these? And I think that's exactly what the question is. And they can be many different types of things. And I think it's a looking at what are the various rights and interests and obligations that are a part of them, that come from them, that they represent. So, and I take it kind of looking back historically, when have we gone through this before? And when have we developed, a business form, a new business form, and how did we approach that? And when new assets have been created, how did we analyze them? How did we group them? How did we just determine how to regulate them? And first it starts with these interests, and I'll talk about it a little bit deeper in a second. But those rights, interests, obligations, anything that's there, because everything is something. It's not just nothing. Air is air. It's not nothing, right? So there's everything is something, and then by looking at that, you can start to look at these different types of relationships and transactions. And it's a much deeper kind of analysis than I think, is people are kind of engaging a lot of the time in. It's a very much more basic level. And from there, you can look at what then are like the risks. What are, there's always some sort of an assumption of risk when you have any kind of a transaction, and that's kind of what the negotiation is. Somebody bears some sort of risk, and there's usually some sort of economic incentive, or there's some incentive for that. And then from moving forward, how do these things move together? What are their characteristics? How are they similar? How do they move in a market? Like commodities in stocks, and how does that work? Like you can see that some things are correlated, some things are not. When there's high inflation, you see more commodities being purchased. And so there's an interrelation between all of these things and between the people. So it's not just the assets, it's also the relationship between all of the different actors. And just because I'm not acting myself, but I'm acting through some autonomous something, or I create something that then can go out and behave on its own, that does not mean that it doesn't exist because there's no human. Like, it always starts from a human, right? And if I do something, if I put some code out there and it creates something, that becomes there's some sort of warrant of merchantability, there's some sort of fitness of use. Like, there's lots of different theories of property, of economic principles of the law, of business forms, of torts, right? Reasonable person duty. Like, you still have duties that may then be, you might breach, and it may proximately cause somebody else's injury. And if I do that through, a human being, or I do it through something else, it's something that's autonomous, you still have to think about how all of these things work together. And if you go back and look at when a corporation was first created, the corporate form, originally, it was me, I had a business, and I operated that business, and I was fully liable, my person. You could come after my house. Then we separated out liability. And then I had me, my business, but you could only come after my business. My house was safe, right? And then we separated this, and with shareholders, with ownership being separate from control, and instead of groups of people putting their money in and all working together to do something, they started getting other people to invest. And it's actually, in the grand scheme of things, not that long ago, in 1904, there's this Corporation Commission report talking about the experiment of a corporation and all these various incentives, thinking that the law went too fast, and it created this, these incentives that weren't aligned, and created market issues and fraud and all these other things that we learn about. We talked about for the 29 crash. And they had to look at these questions of, this is new. If I separate wealth, my property of wealth, if I'm separate from it and I give it to somebody else to manage, do I still have those same rights to that wealth that I used to have, that I had when I was doing it? And this was a question that had to be answered. And I think similarly, we're reaching a point here where there are some of those very fundamental questions we need to answer. And so, for example, if you look at it as, and this is not my idea, this is Adolf Berle's idea, but if you have, like, thinking of a shareholder as having passive property, they don't do anything with it, and you have the manager having the active property because they control it. He thought, what happens one day if could you have a property interest in that active property? And I think that the DLT is what created that ability, and that is a new right we haven't seen before. So particularly with governance tokens, and not all, I mean, even governance tokens are different. So that's why we really have to think about what are these, because so a governance token is kind of unbundling and debundling of things that we've already been recognizing. And so I have the ability in a very small part to control with my vote, and then, but, so I own it and I'm controlling it, but only a very small part, you know, so I don't really have the ability to do a big change unless I'm with a bunch of other people or I own a ton of it. But generally speaking, that's what it is. And so, and that's tradable. So this is now a property interest in active property, and we've never had it. So I think it's at least worth asking, like, what is that? What does that mean? How should we think about that? And getting to really like to do that and how the securities laws applies is to ask, what is the sine qua non of a security? It's not Howey. Howey's the definition of an investment contract. There's lots of other things. Howey does not apply to evidence of indebtedness. Howey does not apply to voting trust certificates. That's not the test. And so I think we need to look more at what is it? There's some sort of an economic interest. And if you think about these DLT networks, not as just some piece of technology, but more in the fourth kind of industrial revolution we're in, as like a new business form, a new way of doing things, a new way of allocating resources. It becomes much bigger than that of thinking through what these actually are. And I encourage everybody to dig a little deeper in trying to figure out what they are.
Great, thank you. So we have Chris, I'm paraphrasing, and I'm sure I'm going to get things wrong here, but you know, Chris talking about risks, and Teresa talking in a very fun way about rights, duties, obligations, raises questions about under what circumstances does somebody owe obligations to others, and in a way that gives rise to legal liabilities, and how does that through an obligation responsibility, how does that flow through in terms of thinking about jurisdictional questions, like what's a security? And then, Sarah, I'd mentioned that you were going to be third, and you have a different perspective insofar as you're general counsel. And so how do I have that right? At my job? Yeah. Okay. Yeah, at your job. Yeah, sorry.
I do a lot of things, activism on the side. I didn't know.
Oh, okay, yeah, so I was thinking about that job. Sorry about your job, if I got that right. I think I have that right. So you're dealing with these things in a very practical way is the point, which is a different vantage point in terms of being house and having those responsibilities, a different vantage point. So what's the biggest challenge that you face in trying to wrestle with this question as to whether or not something is or is not a security? Because to make a implicit point that's come through Express, the security question is so consequential because it determines jurisdiction. It determines regulatory jurisdiction. So it's not, yes, it's an interesting academic question, but it's a very practically consequential question. And even if it's not a security and therefore there's not jurisdiction by the SEC, well then it's, again, something, and so somebody else has got jurisdiction. And so how do you wrestle with that? What's the biggest challenge wrestling with that? And is there a particular thing that you think the commission could do or should really consider doing that you think would really move things forward, not to the exclusion of other considerations, but one that may really stand out from your perspective?
So I think that the specter of the application of securities laws has moved early stage projects in the market to sort of take an arc very similar to IPOs where they stay private longer. These assets in the traditional model are designed to have wide, broad, early distribution. And most of the market is hedging that on the application of securities laws, so it ends up looking a lot like your traditional markets where people will basically marshal, their way to an exchange listing without that broad dissemination or price support or, actually fully launching the technology. And we see more and more the token is the product. There's attention economy models, and prices being more, I guess, there's different ways that people are artificially supporting price, like the high FDV, low float model that's come, and it's generally been, I'd say, sort of toxic to the market, with everything structured to avoid intricate structuring to I guess, hedge downside that you're complying along the way with securities laws, just in case it is deemed to be a security.
And so to pick up on that, now, John, I'm going to go to you. From your perspective, having heard Chris's take, Teresa's take, Sarah's take, 3 different takes, and I think that's the whole point here, to see the different perspectives on this. From your perspective, John, you've had a lot of opportunity over the years to think about the intersection of technology and our capital markets and technology and finance and securities regulation beyond just right now in the context of blockchain technology and crypto assets. So how would you suggest that the commission adopt, if you think they need to adopt or adapt, a technology neutral approach to the question of what's a security? And very much related to that, are there circumstances under which you would say, well, if a particular crypto asset had these attributes or rights or obligations or interest, or a lack of these attributes or rights or obligations or interest, or to pick up on Chris's point, these risks or not these risks, that you would say, without being perhaps conclusive about it, well, under that condition, that particular crypto asset most likely would not be a security?
Well, thanks, Troy. And thank you for everyone. And I'm really honored to be among this group. It's an incredible group of attorneys. And Commissioner Pierce, who I knew when she was a staff attorney, I can't say enough amazing words about her and about this task force. I think it's an incredible idea to really recommend and figure out what you want to tell Congress with respect to securities regulation. But I don't see it as something you can tell the courts, because the courts have already spoken. If you look at the statement that I wrote, and I know the statement that Professor Reiners wrote, as far as what is a security, the economic reality of the transaction, however you want to look at it, the people buying crypto are not collectors. We all know that. They're investors. And the mission of the SEC is to protect investors. And how do I know they're investors? Because whenever I go around and talk about this stuff, whether it be on Twitter, X, whatever you want to call it, in a big space, or on 60 Minutes, I get death threats afterwards because I'm talking literally, because I'm talking about crypto and that it should be regulated. And whether you're talking about eel farms or ostrich farms or orange groves, the whole point of securities regulation was to wrap that all up into a very big, broad, principles-based regulation. Principles-based regulation works. And if you read all the cases that I cite in my statement, that Professor Reiner cites, I don't think the SEC, respectfully, can just suddenly say, all these cases don't exist. We've decided that the law is different. The law right now talks about the principle, the fact that the 33 Act and the 34 Act were written to be flexible. And this kind of criticism has been around for a long time. Coming into the building, I worked here for almost 20 years. By the way, I'm president, managing partner, CEO, and director of John Reed Stark Consulting, a company of just one. I have no stake in the crypto world or cryptoverse of any kind at all. I'm pretty much, semi-retired. Telecom I am. Yeah, I think that, so I look at this stuff very objectively, and I think back at the 20 years that I was here. I was 11 years, I was chief of the Office of Internet Enforcement. And it's tough coming in this building today because I hadn't been here for 15 years. And my first day was September 9th, 1991. And I met a guy, Mark Lewis, who would become one of my best friends in the world for 35 years. How many best friends do you have for 35 years? I have some for 50 years, but Mark was very special. And I've been thinking a lot about Mark lately because he's very sick with leukemia in New York. Why am I bringing that up today? First of all, everybody please hope for him. Second of all, Mark at the time wrote an article with then director Bill McLucas because someone had created a shadow SEC and said the SEC was overreaching with all of its regulations about things like insider trading and going off the rails and rogue in everything. And Mark and Bill McLucas wrote this, the director at the time, wrote this article about principles-based regulation and the flexibility of 10b-5 and of things like Howey. And that design was specifically meant, as the Supreme Court has stated, not to cabin the scope of the definition of security. So when you look back at these transactions, these people are buying this because they're investors. And the SEC's, like I said, their mission is to protect investors. And I just don't see how you can, I appreciate the idea that you can say, okay, you know what, these laws can be done better. I remember Teresa Goody's old boss, Harvey Pitt, came in. One of the first cases that I worked on was an insider trading case involving an oil well. And he came in and he said, there's no definition of insider trading and there's no breach of fiduciary duty here. And my client you should leave my client alone. And he was right. When we looked at it, he was right. At the time, insider trading hadn't developed to that. But it didn't mean that, if we recommended that there be a new definition of insider trading, that we stop all prosecution of it, or that we give up prosecution of it. What it meant is, okay, maybe there can be better definition. When I worked under Commissioner Paredes at the time, there was a case called Doroshko, which involved somebody hacking into a system of a company and then trading on that system. That's what Doroshko did. He made like $5 or $10 million doing it. So we charged him. Sounds like insider trading, right? Well, the district court judge in that case said, nope, that's not insider trading. That's computer theft. And I remember I was joking with Commissioner Paredes, who called me into his office at that time, and he said, you got to stop with these cases because a district court has said that, number one, that there's no duty here. There should be a duty lurking, and this is not what insider trading is all about. And I understood that, and we stopped working on those cases. We appealed the Doroshko case, which got overturned. It was sent back because the idea was, well, maybe this hack was a deception because whoever was hacking in there had somehow masqueraded themselves as an administrator, and that was a fraud, as opposed to, it's like dressing up like a letter carrier to steal inside information. That's a fraud. That's insider trading. That's SEC jurisdiction. But if you bang on the window and you walk in, not so much, and just steal the information. So the idea was, so then they came back and it turned out the Edgar system got hacked and somebody was trading on information that they had gotten from people who had done Edgar files. So the SEC ended up bringing one of the biggest cases ever. The only case they brought during the big shutdown was against the hackers who did that. So I get it that you can have some district courts that say one thing or the other, but right now we have many, many courts. It's unbelievable, really, the volume of case law that has developed so quickly, because all of these crypto firms, they went for this sort of delay idea, and they hired the best law firms in the world. And these law firms all fought the SEC with incredible briefs, just incredible briefs. I've read every single one of them. And they lost just about, I would argue, every single time. Digital assets were securities, SAFs were securities, initial coin offerings were securities, staking products were securities, lending products were securities, all because of Howey. How can the SEC just suddenly say, you know what, the Division of Corporation Finance has decided that digital assets are not securities? I mean, there are some members of the states in the audience here, and I'm sure they're saying, well, not in my office, they're not. The SEC does not have this sort of unilateral authority. So I look, Commissioner Paredes, I look at it like, it's hard for me to call him Troy because, again, when I worked for him, he was always commissioner. But I look at it like this law has been decided, and it's out there, and the SEC can't abdicate its responsibility, its mission to enforce those laws. They certainly can get together like this task force with all these brilliant people whose hearts are in the right place and say, this is different, here's what we think Congress should do. But they can't unilaterally repeal the 33 and the 34 Act because of this innovation. And I don't see it as innovation. I see the iPhone as innovation. I see the cloud as innovation. I see AI as innovation. I don't see it. I agree with Commissioner Crenshaw that, you know, the risks are tremendous and it just doesn't outweigh the benefits. Where's the utility? If it all went away tomorrow and you weren't speculating in it, you wouldn't care. So that's sort of how I look at it.
Great, thanks, John. So Miles, turning to you. So I think John's perspective, principles-based, and that essentially the courts have addressed it. And so Miles, from your perspective and the perspective of A16Z, where you're crypto, where you're the general counsel, what's your view in terms of not only principles-based, but in terms of the courts have spoken to it, and how does that perspective reconcile or not, as the case may be, with something that you and your firm have talked a lot about, which is decentralization in the context of crypto assets?
Sure. So I think I'll start off by saying I agree that principles-based regulation is the proper approach, and I'm in alignment with John on that fact. I think from there, though, we start to depart quite a bit. I think it's a straw man argument to say that the people up here on this panel generally don't believe in principles-based regulation and that people are looking to apply formalistic restraints to Howey that would then allow for easy circumvention. I think that there are very few proposals that actually pursue, doing away with principles-based regulation. And I think that is for good reason, right? Most of us that work in the space understand that the nature of digital assets can change. What the underlying network that they relate to can be controlled by a single individual, or it can be controlled by no one and be completely autonomous. And so all of those things change the overall risk profile of it. As a result of that, I think a lot of us believe that principles-based regulation should continue to be the law of the land. The problem with principles-based regulation, though, is, as we've seen, I don't think that anyone could credibly argue that the last administration's approach to the industry accomplished any of the SEC's objectives. It did not lead to investor protection, it did not lead to capital formation, and it did not lead to efficient markets. As a result of that, the current approach is clearly a failure, and we have to do better. Now, some people will argue that means getting rid of principles-based regulation, applying formalistic requirements to Howey to say, hey, if you don't have a legal relationship with the issuer, then securities laws shouldn't apply. I firmly do not believe that is the case. That would allow for very easy circumvention, and such an approach would make it impossible to distinguish Bitcoin from an asset like FTT, which was basically a profits interest in FTX, where FTX promised the market that they would buy back the token with their profits from running their exchange, right? And there was no legal relationship with people that were investing in that token, but clearly the economic reality of those transactions were that people were investing in a proxy into FTX. Pretty good sign of that being a securities transaction was that when FTX shut down, that asset went to zero, right? We do not believe that type of thing should escape the bounds of securities laws, nor do we think that you should be able to escape securities laws merely by providing some additional disclosure on it. We don't exclude brokers, we don't exclude exchanges, we don't exclude notes from being securities simply because there's disclosure provided around them, nor should we do so with investment contracts. But fundamentally, right, if we look at the SEC's approach, if we want to embrace the idea that we're going to do and look at substance over form, right, and we're going to focus on the substance, we have to engage with what that substance actually is, and we have to do the work of defining what that substance is. That does not mean, right, continuing to not provide any guidance to the industry, right, letting the courts decide over a period of years, right, what happens, having decisions that are at odds with one another. Yes, the SEC has won some cases. They have not won a single case that applies Howey to secondary transactions. They've only won on motions to dismiss, so it was kind of a miscategorization to speak about the cases that way. And on top of all of that, right, we have entrepreneurs everywhere, right, that are looking to do the right thing, and what they're faced with every day as a result of this regulatory uncertainty is bad actors taking advantage of the regulatory uncertainty to push to the limits of where securities laws potentially apply, right? Deliberately going over that line, hoping that they don't get caught. Meanwhile, the good entrepreneurs are sitting there talking to us saying, hey, why can't I do what X is doing? Well, because government inaction is not consent. That is a very hard conversation to have with entrepreneurs, and it's one that I have every single day. We are not fostering innovation. We're not protecting investors. We're not helping capital formation. So we have to engage with the substance. Our general approach and the way that we believe that the SEC should focus on the issue is to look at control. That is a technology neutral, merit neutral approach to looking at what differentiates a system like Ethereum from ownership of equity in Apple, right? Apple is a system that is controlled by humans. Ethereum is not controlled by humans. As a result of that, the risk profile of that underlying asset, the trust dependencies associated with that asset are very different. Teresa talked about a second ago, right? She said that one of the things that C Corps did was it allowed us to split ownership from control, right? That's a very important concept, right? Shareholders don't have direct control. They use officers and directors as their proxy. Blockchain systems, right, can have ownership without any control whatsoever. They can function autonomously, permissionlessly, trustlessly. As a result of that, the inherent trust dependencies that come up with a share of stock are not relevant for certain crypto assets that meet, control criteria. As a result of that, we do not think, right, in those cases that securities laws should apply the same way they apply to shares of equity.
Great, thanks, Miles. So, Collins, we've heard a lot of different views. I think some instances where there's some degree of overlap and complementarity, even if there's a point at which there's some departure. Some is a different way to frame, but not necessarily an inconsistent way to frame. Others who think, the courts have taken care of it. Others say, well, maybe they've taken care of it, but there's still confusion and a lack of clarity. And so how does that factor in, setting aside jurisprudence, set aside the role of the courts? How does that impact clarity in terms of a very practical matter? So all these different perspectives and viewpoints so far. So from your perspective, as somebody who is advising early stage companies, and again, that picking up on a point that Miles was referring to, you got to give advice, you got to give counsel, you want folks to do things the right way. Of course, you have entrepreneurs who have really cool, interesting things to do. How do you counsel and advise, not in the context of your client, of course, but just as a general matter, how do you approach that? And is there a particular something that you think would be the most constructive thing the SEC could do or reconsider or double down on in order to try to achieve whatever you happen to think ought to be achieved here in this context?
Yeah, thanks. So I think kind of as a preliminary matter, one of the things that this conversation might reveal is that one of the first things I'm always talking about is whether we're in a capital formation context or some other context. And I think we beg the question a little bit when we start only focusing on capital formation, because to be frank, it's obviously a very significant part of the industry, but there are so many other elements of the industry that are affected by this downstream taxonomical question that get lost in this discussion, and that's often what I'm frequently dealing with my entrepreneurs on. So I represent a lot of people that are in the decentralized finance industry, and so the threshold question of what an asset isn't just relevant for capital formation in a couple of ways, and I'll give a few examples. When you're dealing with somebody who does something like a DeFi front end, and this is a type of application or a website that provides access to an underlying protocol, there's a question first off as to whether they are providing access to that service directly or if they're acting as a mere conduit. And this is relevant because when you're looking at whether you've got this taxonomy of do you have a security or not, there's a question of, okay, well, if this thing is a security, and I am actually acting in a capacity beyond just being a conduit, I may be stepping into the broker-dealer world. If it's not, I may be in some other type of category. Another type of example is if I'm dealing with a type of security, but it's equity or debt, and I'm going to conduct a capital formation type of transaction, what type of regime am I dealing with if I'm in Reg S? Is it a Category 1, Category 2, Category 3 security? So I think those are just two quick examples, but one of the first things that I'm always thinking about is what's the context that I'm operating in? Am I thinking about capital formation? Am I thinking about something else? And are the issues going to be the same that way? And I think that's one of the kind of deficiencies in saying, oh, the courts have resolved this as kind of an aside, because even to the extent that we accept that every single one of these things are securities, and I don't accept that. But even if we were to accept that argument, there are so many downstream questions as a result of that that are left unanswered by courts right now, that acting as though we can just sit and say, all right, well, the courts have decided that some things are securities, we're done here, let's head back here in 20 years, is clearly insufficient. So that's one challenge. And when I'm talking to my founders, whether it's in the DeFi context, whether it's in capital formation, whether it's something else, all of those things are in mind. And I would say that generally speaking, while I've got some maybe gaps or maybe distinctions from where I'd say Miles' kind of theories land, I'm generally aligned with, I think, the notion of control being a central feature of our assessment. Now, I think, again, that's relevant for both an exemptive framework, but also taxonomy questions. And I think that's also something that we need to maybe delineate some as we get through this conversation, because some of us are talking about purely classifying assets as securities or non-securities. That's at the top of the funnel, although arguably the very top of the funnel is, do we have a securities transaction or do we have an exempt security? But once we get past that, then the next question is, do we have a security or a non-security? Those are top of the funnel, I guess, questions. But after that point, I don't think we've got, what's the right word here? I guess, I don't think we have the right substance to get to the sub-points of our assets. So for instance, in I believe Miles's comment that they submitted, they've got a proposal where you look at, once you're in the securities world, what type of asset might this thing be? Is it an asset-backed token? Is it a token with intrinsic securities, properties? Is it some other type of thing? Those things will probably all have relevance for the type of exemptive relief that may apply. It doesn't necessarily mean that all those things aren't securities, but it might mean that we may not need to have certain types of disclosures for certain assets that inherently provide information in the operation of their system relative to something like FTT, which I think they refer to as company-backed tokens, where it seems very clear to me that our traditional frameworks would apply. So I guess going to, I think your original question was, what do I think is important? I do think the element of control is important for exemptive frameworks. It's probably important for taxonomy questions, but I think first getting through one, delineating transactions for securities, getting a framework for just easily establishing a security bucket versus a non-security bucket, and then looking within that security bucket and saying, okay, if we're gonna have exemptive frameworks, does something like Reg D work for these types of things? I'd posit that it doesn't. Something like, Commissioner Purse's 195 framework or some of the other people's frameworks up here probably surface more relevant information than our current exemptive frameworks. And so I go back to kind of my point earlier, I think it's hard to say right now, even if we all accepted that every single thing was security, we'd still be doing the public a good service by saying the current framework works fine.
And so, Collins, I take the point there, and feel free to correct me if I summarize at a high level incorrectly, and then Ben, I'm going to come to you, being in no small part that, yes, the discussion of is something a security or not, but that, as you said, that's top of the funnel, that even as to whatever ends up being put into the security bucket, that there are nuances and distinctions within that bucket that then has other effects that one would need to take into account, so that the security, not security, important, but there are subtleties to that, particularly when you get to other topics that the task force will be taking up, which is more about how you substantively regulate. Well, that's not the topic today. The classification and the disaggregation of the entirety of the is it a security, yes, bucket, that disaggregation, classification, nuance, not all assets in that bucket are the same as all other assets, you think proves to be important when it comes to the substantive regulation that they'll get to down the road?
Yeah, I think I'd say it's probably critical, to be honest. I mean, I think today if we solve the problem of like, hey, what's a security and what's a non-security, so many questions, like Rule 12G, for instance, like, can I have 2,000 holders of a token or not? Well, that's going to depend on what it's a security. Is it an equity or is it a debt security? That's not resolved by somebody telling me today that like the thing is a security. So yeah, I think it's absolutely critical.
Great. Ben, you two have unique perspective. You were at the commission for a long time. Now you're at a firm that focuses on policy, where you're focusing on policy. So given that, I wanted to focus with you on, and in some sense it goes back to what Chris was saying, but I think there's a current of it across the comments, including what John was saying, which is that one can take a step back and think about what are the overall driving policy considerations that inform the federal securities laws as they have long existed, And then when one identifies those policy considerations, how does that inform? One doesn't want to overstate, but I think the point is how does that then inform how you think about the threshold question, whether something is or isn't a security, or the type of security it is, even if it is a security. So as you've approached it, how does policy generally, but the policy that motivates the federal securities laws, inform that assessment as to whether or not something is or isn't a security, given what the objective of the federal securities laws are to begin with?
Thanks very much, and let me thank the SEC and the Crypto Task Force for this event and for having me. I want to echo what John said about Commissioner Peirce. It's been a privilege to work with her in the past, and I have nothing but the highest respect for her and the work that she does. As to the question, I think the policy is so fundamental to this question, because I think what has to underlie every policy decision that the SEC makes is the SEC's mission. And I totally believe in the three-part mission. I believe capital formation is important, I believe fair and efficient markets are important, but I also believe investor protection is very, very important. And so when you're thinking about the question of what is a security, I think you have to think about, well, how can you best protect investors? And so I think about it from the perspective of investors, and I agree with what John said, that from my perspective, investors are purchasing crypto assets as an investment. And I think that, that should inform the question. I think if investors are being marketed these assets as an investment, being told, hey, if you buy this, if you give us your money, we'll do things with the money, and then you can profit from it, that seems like a security. And I think that has to inform the discussion. I went yesterday to look at the websites of some large broker-dealers, and on the webpage of a lot of them, not all of them, but a lot of them, there's always a tab about products that they offer. And in a lot of cases, they say stocks, bonds, mutual funds, ETFs, crypto. I struggle with the idea that only 4 out of 5 are securities and not all 5. But even if you disagree, I worry that investors would be confused, right? Can it really be the case that they're going to understand, even if you envision a world where all crypto assets are deemed to not be securities, are they going to understand that, or are they going to not understand that and be put at risk as a result? And so I think that that question of how can you best protect investors and how are these products being marketed to investors is really fundamental.
Can I just jump in only because I've heard the Chris view just mentioned a couple of times, one of the occupational hazards of going first. I did want to just for clarity, when I was starting, and maybe this is helpful for the conversation or maybe it's not. Ultimately, the question was framed for, well, what do you sort of think about the optimal sort of elements of a crypto regime? And to reiterate what we've already heard, there are different objectives. There's investor protection, and capital formation is also very important. And by the way, capital formation itself creates all kinds of interesting questions as to the regulatory perimeter. But once you do fall in that perimeter, the commission does have plenty of rulemaking authority. It happens all the time. I mean, courts make decisions, commissions then go about and they craft rules in response. They have exemptive authority, even with regards to primary legislation. The risk element was, you have to have a starting point for saying, okay, well, why are we involved in the first place? And then you have to take the secondary step of identifying, well, what's the appropriate regulatory response? If there isn't any, and this is, I guess, to echoing different folks at different times, but caveat emptor is not a regulatory strategy, and that's what we've had, and then you end up, complicating efforts to both protect investors and also to promote capital formation, and that's a challenge. Now I said my piece. All right, thanks.
Great, thanks, Chris. Rodrigo. So you've been had a fund, now you're practicing. From your perspective, having had the chance to hear what's been said, as well as just your experience, is there one thing in particular that you think the commission could or should do, or at least could or should consider doing?
Thank you, and I'm Rodrigo Seda, Special Counsel at Cooley. So maybe I'll try to respond to some of the earlier comments and get to the conclusion of what I think they could do. I think it's key first to understand that just because there's investment intent behind a purchase doesn't turn that transaction automatically into a security, right? I think that's a logical fallacy and something that would basically mean that securities law would eat the world and not one where I want to live in, right? So I think we have to be careful about the way that we shape this regime, understanding that we need to protect the capital markets and make sure that we don't create any loopholes, but also make sure that we're developing a framework that doesn't end up, again, consuming the world. I, for example, was talking yesterday over dinner about how I like to purchase art. Last week I was in New York. I purchased a piece from a young artist, partly because I liked it, I thought it was cool, but also it was somewhat of a bet that he would keep working, and he had a couple of shows lined up that I thought were interesting. I don't think that means that that transaction all of a sudden should be regulated as a securities transaction, right? I think I want to push back a little bit on this idea that the case law has been clear when applied to crypto, right? I think it's important to distinguish between the couple of waves of enforcement that the SEC brought. The first wave was really centered around ICOs and fraud. And it was mostly against defendants that didn't have the money or the incentive to fight a SEC enforcement. So a lot of those ended up in settlements, right? And I think from some of those we can take the premise that when you're selling crypto assets in a fundraising transaction, that fundraising transaction should be regulated by securities. And I think most of us on this panel would agree on that, right? I think the second wave of enforcement that focused more on intermediaries and brought pure registration violations, and it also targeted as defendants companies that had the resources and incentive to fight a bet the company litigation, resulted in a much more mixed bag of results, right? I don't think the SEC itself was clear in those cases about what it actually considered to be a security. The judge, in the Binance opinion, kind of chastised the staff about this, where they had flip-flopped between what exactly was the investment contract. And then I think we can't look over the fact that there was a split even in the same district court over how we extended to secondary transactions when you look at Ripple and you look at the Terra opinion.
Yeah, if we could just not talk about any specific cases, that'd be great.
Sorry, apologies for that. Anyways, I don't think it's true to say that the law is clear. And from the petitioner's perspective, I can tell you that I don't know what the law is. You have to somewhat try to advise people from general principles here, right? I think it's also important to understand that the current regulatory framework, the securities regulatory framework that is premised on registration and disclosure, is not fit for purpose for all crypto instruments. What might apply for fundraising transactions, I think if we just fit crypto, if we jam it into securities, we're going to end up deprecating a lot of its unique qualities, right? Crypto, at least for me, the reason I got into this space was because I saw it as a technology that enabled a new form of human collaboration, right? It allows people to come together in a digitally native way and collaborate over open source and public goods in a way that wasn't possible before. And it gives people technological rights within a system that I think are, or I guess I should say technological powers within a system that I think are different from legal rights. So I don't think that just forcing the registration and disclosure regime onto these systems is going to really address the policy goals. And if you follow the downstream effects of doing that, I think it actually really handicaps the development of crypto in the United States. Yeah, and I guess finally, to kind of respond to the idea that the SEC has predetermined that certain actions or certain tokens are not securities, or they've there's some whiplash here. I think to me that is an attempt to regulate with humility and a sense of responsibility that is very important, and it comes from the premise of like we're all here with varying points of disagreement. It's required of a regulator when they're doing their job to, I think, first clarify these points of disagreements before you take somebody to court and try to figure it out there, right? So I actually commend the SEC on their new approach of like engaging with industry, and I think, frankly, needs to be a lot of work done to rebuild those channels of communication and trust between industry and regulators that I think are ultimately going to leave everybody off in a better place.
Great. Thank you, Rodrigo. So, Louis, so you've written a lot on Howey as applied to crypto, and as I understand it, one of the distinctions you've drawn often in your writing is an investment contract, if it exists, from the token or a token or a crypto asset. Can you explain more conceptually that distinction, and beyond conceptually that distinction, practically how does one identify when that distinction actually exists?
Sure. Thank you, Troy, and thank you, Commissioner Peirce, and to the whole SEC staff for, I just second Rodrigo's thoughts of the importance of just our being in this room today. It's really a miracle, and to be honored to be on a podium with such great scholars. Yeah, so one of the things that comes from reading, an inordinate number of Howey cases, more or less all of them, is, patterns do develop. And one of the things I wrote a lot about is really where do we locate the idea of investment contract, even predating Howey, as we all know, comes from state law. And it's redressing an issue. Sometimes people couch what purport to be commercial transactions or arrangement. Hey, would you like to buy, a chinchilla, for example? Got a farm, you could have some of them. And people know you don't really want the chinchillas. What you want is to experience the business that person is running. And so you fund them and they pool that capital, and you've got some sort of ineluctable modality of chinchillas there. Those transactions, courts over the years have struggled with. Sometimes the SEC has won, sometimes they've lost, sometimes private plaintiffs have won and lost, but they've looked at the fundraising and the pooling of capital and the relationship, which, with all respect, Miles, I wouldn't call formalistic at all, the relationship between the parties. And they found that in some cases, notwithstanding the parties couching a transaction, a fundraising, as commercial, hey, would you like some of whatever it is that I've got? Really, what the economic reality was is that people were seeking to invest. What the Howey case law has just really never addressed is what happens if you could create an investable asset that people could buy and sell and trade very easily. And that's just outside the scope of Howey. I wouldn't say it's in or out. So we have to think about how to apply that. And really what we're talking about here is not seeking to use the securities laws to punish people, but rather seeking to use the securities laws for their intended purpose, to address transactions in the marketplace. And when Bob and Alice, transact in ETH or they transact in some other token, those secondary transactions, those market participants need to be able to determine on their own, without consulting high-priced lawyers, without reading code, without studying the current state of a multi-sig, they need to figure out, hey, am I engaged in a securities transaction or am I not? If you could simply look at a token and say, oh, I see, there you go, that would be one thing. But if we create a construct in which every time any market participant needs to decide, am I engaged in a regulated activity, they have to make a time-consuming, expensive conclusion, then that really is very, very problematic from a market efficiency point of view. So the distinction is, when do I have something that is an instrument that no matter how it is dealt with, and I think Collins, I'm glad you brought up Section 12G because it's a good example. You have to know, is this something that's going to trigger 12G? As a broker-dealer, am I custodying a security or customer funds, or am I not? There are many places where you need to know, is this thing sitting there by itself a security or not? And that's an important distinction that our securities laws need to recognize. Now, maybe we'll be better off with something that Congress decides, here's a new framework and here's how you think about crypto assets in the round, whether or not they're securities. And I think something could be said for that. But for right now, at least, we need to be able to make those distinctions so that market participants know when they're dealing with it. The people selling and fundraising, in most cases, can figure this out. And they're the ones that, in my view, should have that duty to figure out. They also have disclosure obligations. I think really, Troy, that what has been the greatest point of consternation here is because there hasn't been a pathway to properly sell these assets to the public, what we have are assets being sold in private transactions with little or no disclosure and then publicly traded, and a real absence of what the securities laws really are trying to address. And personally, I hope we can find a way out of that that problem.
Just to add, and I won't say I necessarily disagree with Louis in the sense that I'm not sure, maybe if everybody's read his paper, there's maybe a sense that there should be a potential blanket, let's say, exclusion on secondary transactions. I don't take a position on that, but I do think historically our laws, and both the federal and state laws, have taken a position as to delineating the securities and the transaction itself. I think obviously we have Section 3 exempt securities and then Section 4 exempt transactions at the federal level. But then at every single state level, I think somebody said there are state regulators here, so they can obviously confirm. But at every single state level, we distinguish between exempt securities, usually in the prior section, and the transaction itself. So I think the past century of both legislative and rulemaking and jurisprudence does acknowledge that there are times where the transaction itself is obviously the focus of our inquiry, and then there are times that the asset itself is the focus of our inquiry. Sometimes those things may be one and the same. I think in particular for crypto, it's probably difficult to get to a place, at least from my end, where every single crypto asset would not be a security if it was only in a secondary transaction. And at the same time, there are probably some crypto assets that even if they weren't sold in exempt transactions, would inherently have properties that would make them securities. But I think that distinction should definitely not be one that seems to be somewhat controversial in some circles, because we've had that framework for almost a century now. So.
Great, Collins. Thank you for that. Lee, moving on to you, and then that's going to leave Coy, and then we're going to get more interaction among all of you. But Lee, what's your take? My sense is that your view, and again, correct me if I'm wrong as I try to summarize, is that the question has, to some extent, as to what's a security in the context of crypto, maybe more than just to some extent, has been asked and answered by the Supreme Court and by the courts over the years. Is that a fair summation? And how do you think about the following aspect of it, going back to various things we've heard, which is you take the four prongs of Howey, for example, or even a principles-based approach. There's still then, the practical question as to, but how does it get applied to any specific set of facts and circumstances? So that kind of translation of a four-part test or a set of principles to actually being applied to concrete real-world facts and circumstances and some of the tough judgment calls. How does consideration of that, if it does, factor in terms of your take as to what constitutes a security when it comes to crypto, and if there's anything for the commission to do to provide additional clarity or to rethink the approach?
Sure. Thank you, Troy, and thank you, Commissioner Peirce, for hosting us and the staff for putting this together. I know from experience that events like this take a lot of effort, so certainly appreciate it. So I'm Lee Reiners. I'm from Duke University, and let the record show that we tipped off about 10 minutes ago. So go Duke. Let me also note that there's quite a bit of distance here between my fellow crypto skeptics, so feeling a little isolated up here. But let me just start off with a note of agreement on some of the things we've discussed. And obviously, we're here to start with, as we said, the top of the funnel. When is a crypto asset a security or not? But then I think sort of once that is decided, and I think it's pretty clear, and I agree with John that. Courts, not just in SEC enforcement cases, but in private litigation, and state enforcement actions. And let's not forget, the states have been the earliest on the scene when it comes to crypto. But after that, I think it is pretty clear, in my opinion at least, that some of the existing rules are not necessarily fit for purpose, and I think disclosure is exactly one of them. I don't think it's controversial to suggest that the information an investor in a crypto asset would want is just fundamentally different than the information an investor in, Apple stock would want. I don't see how that's controversial. And obviously there's been custom disclosure frameworks provided in other contexts, asset-backed securities. And so this is something that Chair Ueda has suggested, and I would certainly be open to. Another issue, of course, is, well, should a broker-dealer be able to offer securities alongside crypto assets that are probably commodities, right? And I frankly don't see the issue with that, provided certain risk controls are in place, and that's perhaps an opportunity for the Commission to use its exemptive authority, as others have suggested. So I put all that out there to know that I am not necessarily disagreeing with my fellow panelists on every single issue, but look, the Howey test is a flexible standard, and I have to disagree with Rodrigo's disagreement with John, and in over hundreds of cases, right? Judges have applied Howey's 3 or 4 prongs, depending on your perspective, to the offering of digital asset transactions, and found, in fact, there was a presence of an investment contract. I think, look, one issue that Lewis raised, and I put in my statement, is this notion of what I call the separation theory, and as Lewis pointed out earlier, perhaps I should have called it the embodiment theory, and this was raised in a ruling that Rodrigo referenced, but I will not reference it because I will follow the rules. In which case, sorry to throw you under the bus, Rodrigo. In which a judge, pointed out that the subject of an investment contract is separate or different from the investment contract itself, right? So, Citrus Groves itself were not an investment contract, right? But when packaged with Howey's promise to manage those and distribute profits, then the whole sort of scheme became an investment contract. And so I kind of grappled with this in my statement. And where I came out with is that there's a fundamental difference here between the subject of a security scheme and the security instrument itself, and that difference is the means of participation. So no one received Howey's promised earnings distributions by simply buying the orange groves, right? On the contrary, a token issuer promises profits by impacting the price of the token. Therefore, all the purchasers of the token receive profit through the issuer's efforts. And because tokens are fungible, it's impossible for the issuer's promise of profits to be paired with some tokens and not all tokens. So whereas the fortunes of 99.99% of Orange Grove owners have no relation at all to Howey, the fortunes of all token holders are dependent on the token issuer. So therefore, I think it's pretty clear the token is not merely the subject of the scheme. It is the security instrument itself. And I think if some of these cases been allowed to proceed, I think that's certainly where courts would have come out. So again, I think, Howey's flexible, it's facts and circumstances dependent. Another thing that's sort of come up is sort of the role of decentralization. We would probably all agree, I'm guessing, that Bitcoin is not a security, it's not an investment contract because it is sufficiently decentralized. There are no, there's no common enterprise. There's no others to point to receive your expected profit. So of course that raises the question then is, can we draw a line where something is sufficiently decentralized to no longer be considered an investment contract? And I just think that's an impossible line to draw. And I would point folks to the CFTC's report that came out in 2014, or 2024, I'm sorry, is a report from the Technology Advisory Committee on DeFi. And the members of this committee that put together that report were mostly worked in the crypto industry, including at DeFi firms. And they noted that decentralization exists along a spectrum across multiple dimensions. So you have governance, asset, user, application, data, network, protocol, hardware. So how do you determine when these dimensions are sufficiently decentralized enough to ensure profits don't come from the efforts of others? I just think, again, that is a completely futile task for any agency to try to attempt. even if you do attempt it and you suggest, okay, we think in these conditions it's not an investment contract, it's not a security, well, then it may be a commodity, and you might have the CFTC making a ruling that you don't necessarily agree with, right? So finding that DAO governance token holders who vote their governance tokens can be held jointly and severally liable for the actions of the DAO. And so this is why I think it's best to just leave it to the courts and have it be facts and circumstances dependent, because otherwise you're just never going to get to, I know we all want to get to this sort of promised land of clarity, and I don't think you'll be able to do it. And my final point is, look, whatever outcome of this task force, and perhaps there's sort of a new guidance in terms of how the SEC is going to apply or interpret Howey to digital assets going forward, that doesn't mean that courts have to follow it, right? And to the extent the SEC is no longer going to be an effective cop on the beat when it comes to crypto, that void is going to be filled by private plaintiffs, okay, who are going to perhaps have a different interpretation of Howey. And in fact, we have seen numerous cases in which courts have agreed with plaintiffs across, not just digital assets, ICOs, but even NFTs, that they found to meet the definition of an investment contract. States are not going to stop either. So while the purpose and intent may be to provide regulatory clarity, the effect may actually end up being the opposite. And now, I just want to end on that sort of note of caution to those who are doing this great work.
Great, thanks, thanks, Lee. And then Coy, to you. So
Best for last.
yeah, and then if there's stuff folks want to react to, reply to, try to get my attention, Teresa already has, and I got a question or two ready to go, which I may get to before Teresa I get to you, just because I think there's a topic that I haven't heard mentioned that I want to make sure we come back to, and I'll let whoever wants to respond. But first, Coy, we've heard a lot of different perspectives, including the perspective that that Lee just mentioned, which is, if it were, as I understand it, and Lee, again, correct me if I get this wrong, if it were to be the case that the SEC were to be perceived to be scaling back its role from an enforcement perspective, that others may see that as occasion and or opportunity and or reason to fill that void in some way or another, which may then beg the question as to, on a net basis, where did things come out from a clarity perspective or otherwise, which speaks to a general point, which is things are dynamic, right? That if this changes, other things change in reaction, and so how does the whole system come to rest in terms of some equilibrium? That's much more complicated than a more static analysis where one presumes everything is the same other than the one thing that changes. I think Lee gets to kind of at a bigger picture level the point that you're making, if I, again, understand it correctly. So, Coy, from your perspective, as somebody who's practicing in the area presently, and you think about those kinds of dynamics, you think about the fact that there is a lot of jurisprudence on the books for a lot of decades now, as Lewis mentioned, having read all the cases. You also think about the reality that applying, I think, anything that's a set of factors or considerations or principles to, real facts and circumstances, there are judgment calls to be made in terms of how to proceed and what regulations apply, what regulatory bodies have jurisdiction or not. So in light of all of that, where do you stand on these questions? And again, come back to a common question I've asked a few folks. Is there a particular something that you think the commission should or could either do or consider that would make a big difference?
Yeah, thank you, and thank you, Commissioner Peirce, and to the task force for having me. I think Rodrigo used a term that I really want to zero in on because I think it's directly responsive and maybe colors all of my comments. The term of regulatory humility, right? Lee, you're absolutely right. The SEC is not the only player here. You're going to have private litigation, but the other big issue that's going on right now is Congress is actively considering legislation that would assign spot market trading oversight to potentially the SEC and CFTC, or potentially just to the CFTC, right? So, these academic arguments are important and good, but at the end of the day, Congress is actively looking at this, and while they won't provide clarity on every single thing, they may provide clarity to the SEC and limit what it can do in this space. With that in mind, we've had a lot of discussion about are these assets securities or not? And I think that's a little misleading. I think of the assets in the context of a transaction, right? Like, I understand we're here, we're talking about policy too, but the SEC has to keep themselves limited to the legal analysis. So you have to start at the statute. Teresa mentioned all the different instruments that count as a security. If you don't fit as an equity, you don't fit as a debt, you don't fit as a certificate of interest, all these things, the only thing you have left is an investment contract. So for most crypto assets, we're talking about investment contracts. That requires a contract, a transaction, or a scheme. So we're talking about transactions, right? And notwithstanding Lee's arguments about the embodiment theory, to date, no court has agreed to that, and it's a point I certainly see the argument. But there is no regulatory pathway for an embodied investment contract to have a secondary market at the SEC. It's just something the SEC has never contemplated before. It's just not a real legitimate pathway forward. So I think from the SEC's perspective, in limiting themselves into transactions and thinking of how they can provide clarity, keeping in mind the humility that Congress is looking at this space, it's starting from a principled theory of what Howey covers, what types of transactions it covers, and what it doesn't. And so I think, as they've already started to do, and I applaud the work with the meme coin statement and the mining statement that came out, proof of work mining, is identify just certain transactions that you are comfortable fall outside of the securities laws. Or conversely, if there's a problem, if you think there's certain risks that certain transactions do fall within the securities laws, well, soliciting public input on that would be really helpful and useful, right? So I think, certain things that just happen, staking as a service, airdrops, stable coins, things like that, just basic transactions, secondary market transactions. I know there's ongoing litigation that we can't talk about. These are things that the SEC, I hope the task force will be able to look at and start carving out and carving in. Maybe the other important point that I just want to drive home here is that this is not happening in a vacuum. All of the activity that is ongoing is going on right now outside of the securities laws, with some notable exceptions, obviously, of folks that are fundraising pursuant to Reg D and the like. So if the SEC is going to inject itself into different transactions that has not injected itself yet, I think it better to have a couple things in mind. One, it should obviously have a sound legal argument of why this is a transaction that is subject to the securities laws. Two, it should have a clear policy goal of what it's trying to achieve, who it's trying to protect, and why. And three, without even knowing the transaction, I can guarantee you there's not a pathway currently at the SEC for that to be achieved in an efficient manner. So I encourage that in the same breath, the thought of if something is within the securities laws, the immediate conversation needs to pivot to how can compliance with the securities laws be met? And a more proactive agency from what we've seen in recent years would be very welcome, and I'm super encouraged by the efforts so far by the task force, and am grateful that you're doing the work that you're doing.
Great, thanks, Coy. I know Teresa has some thoughts that she got my attention on. Is anybody else maybe everybody, but Teresa, John, Collins, anybody else? Lewis. I'm going to do my best here. Anybody else? Let's see, Miles. I think I'll just go through the list here, it looks like. So I thought might be the case. Anybody else? Anybody else? Yeah, okay, Ben. All right, if I miss you, and if there is anybody else as we get through, just chime in. So maybe in that case, I'm just going to go back through, or I'm going to bounce around a little bit and exercise some moderator's prerogative here. But there is a question, and I'm going to ask everybody to be brief in their kind of next comments, but also in response to the following, and maybe somebody just get my attention if they want to take this up. One of the things that I didn't hear mentioned, and I may have just missed it, is express discussion about use and consumption as compared to investment. So you think about United Housing versus Foreman, which is a really important part of the jurisprudence, as well as market forces versus efforts of others if you're looking at it from a Howey perspective. Right? There's a lot of things that can influence a price, but that doesn't necessarily mean, according to the courts, that it's the kind of efforts of others that would satisfy that particular prong of Howey. And there's case law, not a ton, but there's case law to that extent. And again, use consumption, you think about in the context of Howey itself, to twist the facts to what they weren't, but just to illustrate the point. If in Howey it had been the case, it was not the case, but if it had been the case that the individuals involved could have come into the groves, picked some oranges, eaten some of them, given some away, maybe set up an orange stand, maybe went to a farmer's market, that case very likely would have turned out differently, or at least there was the prospect that that case would have turned out differently. And I think there's really, you see that in United Housing versus Foreman in terms of use consumption as juxtaposed to investment. And then there's another layer to it, which is speculation the same as investment? I think some folks talked about that to suggest that speculation is not the same as investment, that there's a lot of things people speculate on hoping that it becomes more valuable that folks wouldn't think of as being a security. So if you take those points, which I think hover around a lot of the discussions over the years as to what is or is not a security, in particular, the use, consumption, United Housing versus Foreman, and if market forces are the thing that are determining the price as compared to meaningful efforts or managerial and entrepreneurial efforts of others. Anybody want to offer a perspective or two? Miles?
Yeah, so I mean, I think that the SEC actually got this right back in 2017 and 2018 when, they basically said that the presence of utility is not enough to exclude an asset from the securities laws regimes. I think everyone would agree here that if Amazon started accepting Amazon stock to pay for AWS services, we wouldn't exempt Amazon stock from securities laws, and I don't think that we should do the same with digital assets. It's undeniable that there are people that are investing in digital assets. It's undeniable that some of those have use cases. But trying to grade the line between where there's more consumptive intent than investment intent, I think is even more impossible than defining sufficient decentralization. So as a result of that, I think that's kind of a bridge to nowhere. I think it's easier to focus on the efforts of others and where the value is being derived from a given asset. Again, going back to my example earlier, with Ethereum, there is a financial interest in the operation of the network. That network functions without human intervention and control. It's fully autonomous and permissionless. No company going away could harm the economic value of that asset. Compare that to a share of Apple stock or FTT, right, where the clear economic value was derived from the profits of an enterprise that were then being deployed back into that asset. And so I think, again, the efforts of others, I think, has been in the 2019 framework that the SEC put out was used as a very expansive way, 40 different factors of very subjective nature, which has been very difficult to enforce. And I think that if we can constrain it to a more objective perspective, one that's focused on control, it's a lot easier to define what decentralization is and what may de-risk an asset and therefore justify not applying securities laws.
Good, thanks, Miles. Sarah?
Just as a small point, right, I think there's two extremes here of one, your asset got infected by a securities transaction and is a security forever. And on the other end, there's sort of people arguing for more of a four corners test is based on the intrinsic characteristics of this asset. We wouldn't consider it a security, but the thing about tokens is they aren't oranges. Like, while the issuer or the initial development group retains control over all aspects of the network, the dApp, the token, they can inherently change the functionality of the token. The token is whatever they want it to be, today or tomorrow. And so that won't give us certainty. And so that's why I do agree with Miles that there's this inflection point where they no longer can control those characteristics, and then it is de-risked.
Chris?
Yeah, I just like to, I'm pretty, I guess, sympathetic to a kind of control standard. I mean, insofar as it's not foreign to securities law in any way, right? I mean, when you think about, definitions of what constitutes a distribution, or when you think about minority shareholders and their rights towards others, that's certainly cleaner than utility. And yes, so the Supreme Court on various occasions has tried to sort of draw that line between the two. Maybe since we were asked to give each other questions, you have any suggestions in terms of how you would actually implement this? Is there like a percentage number that you have in mind in terms of control of network or
Well, I think it's very important when we talk about control, right, that we're not talking about just the disbursement of control. So while I think that there is some importance in looking at thresholds, right, I don't think if you were to just solely say, hey, look, if everyone owns 1% of this network, then it's not controlled and therefore we don't apply securities laws. I don't believe that that's correct. I believe that partnership interests can be securities. Partnerships can be very decentralized. Right, but the difference between an ordinary partnership that might be decentralized and a blockchain network, right, is that you can eliminate mechanisms of control, right? You can make it impossible for anyone to actually change the system and thereby like influence control. And where you have that, right, you eliminate the ability of anyone to unilaterally affect or structure the risk of the underlying asset, right, and affect the probabilistic outcomes associated with that asset. And as a result of that, so if you look at things like autonomy, permissionlessness, right, all of these things that transform blockchain networks from being proprietary software like Apple's App Store into things that function more like public infrastructure that no one controls, I think that's really the core criteria. So I think, voting rights, voting power is part of that, but I think it's only one part.
So just to clarify, Mo, so control means that you could modify the code, and if no one can modify the code, there's no control?
I think the mechanism for modifying the control is certainly a worthy kind of criteria. But for instance, there are systems where no person can modify the code whatsoever. Uniswap is a smart contract protocol that has smart contracts deployed, which is programmable, executable software deployed to a blockchain, right, that are completely immutable. No one can change how they function. As a result, no one can change the economic value of those smart contracts or the economic value of the token that relates to those smart contracts.
But what if an entity can just release an updated version of the protocol that's not the same as the previous protocol, but that's where people migrate to?
Well, so what the critical criteria there is, you're absolutely right. Someone could deploy Uniswap version 20 tomorrow, right? But where do the network effects of the system accrue? Right, and that's what the key economic kind of decision or analysis relates to. Network effects in a system like Uniswap and a system like Ethereum accrue to the network. Therefore, they accrue to the token holders. If someone tomorrow was to say, hey, we're going to deploy a new version of Uniswap, that version of Uniswap would have no liquidity in it. Therefore, it would be completely valueless. The only way it would ever have value is if people moved liquidity from prior versions of the protocol to that version of the protocol. As a result, right, that clearly demonstrates that the network effects of that system accrue to the protocol and not the company that deployed it. And that is a very key distinction for the overall risk profile of the underlying asset.
But Miles, in fairness, I'm sorry,
Lewis, we just pause for one sec. I want to try to get some of the, and Lewis, you're shortly in the queue, so you can kind of refresh on that. So we got about 10 minutes. So I'm going to ask everybody to be quick in terms of their responses, and then we'll have the break, and then we'll have after the break, and we'll figure out to make sure everybody has a chance to get their thoughts in, and then we'll go to the questions that have been submitted. So let me, if Lewis, you can just hold off for 1 sec, and Teresa, let me go to you, and then to John, and then to Collins. We can be quick, and then we'll see where we are from there in terms of timing.
Thanks. So a couple things I just think are really important to think about is Howey was never intended to regulate an entire industry nor technology. If you look at what it was originally, it was more kind of these one-off situations. And after we saw, like, what was happening in these new assets, and the 21A report, indicated that, and how the commission was approaching it. From there, once you see that this is an entire burgeoning industry, Howey is not the appropriate test, in my view. And I think that that's when you have to start thinking about what is this, and just like we have historically throughout our entire, through the United States just being in existence, how we've handled these things, it would be, start thinking about how to apply, what should apply, think more about what these assets are. And then I question the responsibility, how responsible it would be to just let this play out in the courts, this test that's very movable, no limits. It's had problems before the digital assets industry, and it's going to have problems afterwards too. And I think we can also look to, there are other aspects of the securities definition that are triggered by digital assets. Yes, it's most often investment contracts, but absolutely 100%, no way does that cover all of them. There are other types that are not an investment contract, and I think that's important when you're trying to figure out how you're going to analyze these. And I also think it's important with people talking about the tripart mission, which is, the tripart mission is very important, all three equally important, and that all of those were supposed to be done while mitigating or minimizing intrusion to legitimate and honest business. And if you look through, particularly from the Thompson bill, and I'll wrap up, the Thompson bill, which was rejected because it was too onerous, and you look at how that evolved into the 33 and 34 Act and Roosevelt's statements, all of this, so much focus was on the fact that it has to be minimizing that effect on honest business. And I don't want us to forget that, because we have forgotten it for a while. And there are other instances we can look at, and particularly with people thinking that Howey applies to everything like this, is in the 50s, in 1958, there was a trading stamps release. And those trading stamps, the little gummy stamps, and you put them in your book, and everybody would get these stamps, and they were worth like nothing, maybe a penny of that, And there was a $168, I think, billion market for these things, and there was secondary trading and all sorts of things with these little gummy stamps, and the issuers give them to the distributors, and then there were the merchants. There was this whole infrastructure, and the SEC opined that those were not evidence of indebtedness. They did not even consider Howey. 12 years after Howey, they didn't even think about it, and they rationed, if we were to regulate this as a security, well then railroad tokens, all these other things would fall in. And clearly, the securities laws are not supposed to handle all of these commercial transactions. And so if an entire industry and technology of trading stamps evolved, we would have to come up with this whole new thing of how do we handle trading stamps. It wouldn't just be looking at it as a Howey test for every single time and letting the courts try and figure it out, coming up with different answers each time. And then there's absolutely no clarity, no fairness. And if you are going to hold somebody accountable, and I think of, you're wearing a white suit and you get sued by the SEC, now you have a black mark, you can never get it off. And if you're going to hold somebody to that, and they're going to have to live their life that way, these are people, and companies are full of people. All of this, let's not forget, we're all people, even though we're talking about technology. And if you are going to hold that person responsible, and then 2 months later say, oh, never mind, it's not a violation for anybody else, where's the fairness in that? Thanks.
John?
Thanks. I'll be quick. There's an elephant in the room to me. There's been the wholesale demolition of the crypto enforcement program, right? It looks like they've closed all the investigations. It looks like they're closing or about to close all the litigation, all the appeals. They've shuttered the crypto unit, given it a new name. They've shipped the head of litigation who did all of crypto to OIT. So is this pivot worth it? I get it. There's definitely a mandate. I believe that the president had a mandate with respect to crypto and wants to be the crypto president. And so I don't necessarily think that any of these steps are something that there isn't a mandate for. But I've taught securities regulation for 20 years, 15 years Georgetown law, almost 5 years at Duke. It's a total gray area, securities laws. If your idea is, hey, we want to make these laws clear, it's just not going to happen in any area. Yeah, I mean, but I appreciate the nobility of the goal. When I was chief of the Office of Internet Enforcement, before that, when I was special counsel for Internet projects, I was an Internet evangelist. I set up the first computer that the Division of Enforcement had with an Internet access and taught people how to use it. I met with e-brokerage firms almost monthly, just like we're doing today, to find out what we were doing right, what we were doing wrong, and really try to work out things to make this disintermediation, that's what everyone talked about at the time, to make all that possible. It was exciting. But there were people out there selling Reg A offerings or Reg D offerings on Internet trading facilities and advising people to buy them. And it was like a driver's ed. Remember those driver's ed films when you were in school where they showed you every conceivable violation? That's what these were. So we sat around and we figured out how to get rid of those. I just don't see it as far as this innovation, whether it's a gummy stamp or equivalent to an American Girl doll or a Pokemon card or whatever. Is this pivot? Is this dramatic, unprecedented, right? Let's all agree the SEC has never done anything like that, like this in its history with respect to such a successful enforcement program. Is that worth it for this this technology? That ask yourselves: is it something that I really care about? And is this pivot worth it?
All right, so I'm gonna keep us on time. I got a couple of minutes left, so here's what I'm gonna propose. Collins was next. I think that's gonna get us to time for the first chunk. What I have in the queue is Louis, Ben, Sarah, and I think Miles. There may be someone on the panel at the break who tells me to get them in the queue as well, and I'll do that. I know that there's the effort, and we will take questions that have been submitted. We'll make sure that we are able to manage all of that, so we give that due time, and also make sure that you all have the occasion. So that's my list. If I missed you, tell me at the break that I missed you if you want me to add. But with that, to keep us on time, we'll wrap up with Collins, and then we'll take the break, and then we'll come back.
Sure, thanks. I think just two final points to respond to. So first, I think that this notion that it's impossible to come up with any type of guidance or framework it's kind of weak. I mean, I guess I'm in Washington, so I can say this in an inspired sense, but like we are America, like we put people on the moon and stuff. We can figure out how to write words to give people more clarity on paper. And I think there's two quick examples of this that came out of this kind of meeting that are almost obvious. So for instance, I think, Lee, as you spoke about kind of your point, one of the things that you kind of inherently did was start positing a vertical commonality test as part of your Howey analysis. I think you said something like, all of these tokens intrinsically link the fortunes of all the token holders. That alone kind of indicates a lack of clarity that the SEC could start working on today. Right now, the SEC has argued both for horizontal commonality being required, pooling assets and bringing funds, and then vertical commonality, where it only requires that you have some type of intrinsically linked fortunes with the issuer. That becomes problematic if you're an issuer trying to figure out if you're already within that regime. One clear example, I think, to finally answer one of your questions, I don't know if any of us did, is what could the SEC do today? I think one of the first things is just start giving guidance as to where their views are, as to what their views are on the prongs of Howey. So to your point, is an investment of money satisfied when somebody receives an airdrop, but it's expected that they create a market for that token? For horizontal commonality or common enterprise, is the SEC's view that it can be either horizontal or vertical, or is it both? That type of guidance alone doesn't require that they come to a decision on what these assets are, but it does give us more predictability as to what we should expect when we're going through these analyses and not going through 50, 60 questions and that type of guidance. So I think that type of clarity, as well as guidance on what type of information is required for a system to potentially meet the type of standard that Miles might be promulgating. And I think that goes to my last point, which is those standards that we look at, and I think somebody else mentioned the original purpose of securities laws. I went back and looked at the 33 Act's first congressional hearing notes, and there was a Senator Sam Rayburn. One of the first things he says is, the goal of this act was to place on parity with management of corporations, the buyers of securities, and then the buyers with the sellers on the same plane as those sellers. And I think what Miles's point goes to is that when you have certain characteristics in a protocol or an application or something else, I think it inherently places on parity the purchasers of that token with the purchase of management. And so to the example that he gave, with Uniswap, your Uni token can't even affect the operation of this protocol. I think there are probably even easier examples to look at where you can say, look, we're looking at this, and at some point when they've lost these elements of control, management has just as much control. They're on the same level of parity as the same buyer. And that's why I think that some type of measure of control is probably the appropriate kind of measure within the context of our historical securities laws. So, yeah, I think we might have a minute for Louis, but I don't know, Louis.
All right, so we'll give 1 minute. So Teresa has a question for Collins, so we'll do that, wrap up in a minute, and then we'll have a break.
What are the characteristics that you're talking about that would implicate the securities laws?
Yeah, so I think, and actually, again, not to, piggyback too much off Miles' paper, but they did a pretty good job of outlining, I think, 3 standards, if I can recall correctly. One was economic independence, and that economic independence is basically what I think he was speaking to towards the end. The other was, as you mentioned, with governance control.
Sorry, I don't get that. What do you mean by economic
No,
independence?
it's totally fine. So economic independence, I think in the example that we were just talking about is, do the benefits and the economic benefits in particular inure to the benefit of the holders by virtue of somebody exerting continuous efforts, and that essentially becomes the essential managerial ones, or does it inure to the benefit of those people by virtue of the operation of the protocol, independent of the actions of that initial issuer? And so, for instance, when you look at a Uniswap, it doesn't matter what Hayden decides to do when he wakes up today. Like Uniswap's value is going to continue to accrue to the liquidity providers that provide liquidity onto the protocol by virtue of the fact that the rules automatically and consistently will always execute in that fashion. But to his point, if somebody launches UniV2, perhaps they add some type of control mechanism into it, suddenly you don't necessarily have that economic independence. It may actually be the case that you're actually dependent on that issuer or that developer to continue doing something or refrain from doing something in order for you to be able to capture that value. And I think that's a good example of where economic independence becomes really critical. The other 2 elements, I know we're over time, I'd probably look at his paper or some of the other folks' papers up here. I think Sarah's done a great job at this, Miles has, and a lot of other people have written about that. But those 3 elements, economic independence, governance, and forgive me, Miles, I forget the last one, are probably 3 good
Operational
starting
control.
points. Yeah, operational control. Thank you.
All right, great. So we are now, in fact, going to take a break. Want instructions?
Enforcement looking jackets. They are friendlies. They are no one to be afraid of. They are just taking your cards. They will not report you to anyone. I mean that. And the second point is, I know we've been getting questions on the web, so please continue to send those as well. We're monitoring them, and we'll get through as many as we can. And finally, we will have a small snack break. So when you exit here, I see some joyful faces. That is also the expression I make when I hear about snacks. So if you exit here and go left, and folks who work at the SEC, if you could just direct people towards the multi-purpose room, we will have little snacks in there and reconvene here at 3:30. Thank you.
Ladies and gentlemen, the roundtable portion of the event is about to begin. Ladies and gentlemen, the roundtable portion of the event is about to begin. Please make your way back to the auditorium, please. Thank you.
Yeah, so people can just lean and it.
Ladies and gentlemen, the roundtable will be reconvening here very shortly. Please make your way back to the auditorium, please.
All right. Is this on? Everybody good? All right, everybody? We do now. All right, we're going to start. You'll notice I repositioned where I am up here. It's a little easier to see everybody from here, so I thought I'd take the liberty to do that. So here's the game plan. We had a number of folks in the queue already. We had a few of the panelists who asked to get in the queue, so we're going to work through the queue. Once again, I'm going to ask folks to try to keep their remarks on the briefer side, but I think still the precision and the like continues to be key as points and perspectives, commonalities, differences emerge. We'll go through the list. We've got a ton of great questions from the audience. Given the limitations of time, we won't be able to get through every single question, so I apologize in advance for that. But I'll do my best to get through as much as I can and to try to probably consolidate some that are more thematically aligned, so we can try to at least hit the topics, if not get to a specific question and intersperse with some thoughts. And again, encourage the panelists to raise questions of each other as they think appropriate to motivate the conversation. So with that, and come back to the list, I probably don't have the exact right ordering, but I think this will do. Lewis.
Thank you, Troy. Well, I think the break gave us a chance to all kind of reflect upon, I thought, an amazing and very, very constructive dialogue. And I think we heard many points of overlap and obviously some points of disagreement. I think that's fantastic. Really the point, Troy, that I was going to make just before the break primarily was the one that I said to Collins. Collins, you're still there. Oh, yeah. Looking in the right direction, which is that the idea of common enterprise, which is a key element of the Howey test, has been sort of left out of the discussion. And I think it is an important concept. Collins, you already touched on it, and I think as many of the folks here know, it is probably the most complex and painful piece of the jurisprudence on Howey. But I think the one point, Troy, that I would make very, very briefly here is that the one thing a common enterprise is not is a common interest. The fact that in and of itself, somebody has a lot of one asset and somebody else has a lot of the same asset does not make them in a common enterprise. They maybe have a common interest in the price of that asset, but it's not a common enterprise.
What if one of them's the issuer, though, Lewis?
I don't know that word. No, because seriously, because the problem that we have is issuer is someone who has an inherent
Creator.
relationship. Yes, there's a creator. So as I pointed out in my submission from yesterday, De Beers is the creator or at least distributor of diamonds. They have a huge interest in the price of diamonds, and they have a lot of control over that market. But you can enter into a investment contract with De Beers. Hey guys, you're a little short on money. I'm going to give you $100 million, and you promise to cut the supply for the next 3 months while I'm liquidating. You totally have an investment contract, an investment scheme going on. You have a pooling of investment of money, a common enterprise, a reasonable expectation of profits, primarily on De Beers's efforts, totally down the middle. But if you buy some diamonds with an expectation that De Beers is going to cut supply because you read something, that doesn't put you in a common enterprise with them. Does not make diamonds a security by itself. That's all. Anyway, thank you, Troy.
Yeah, great. I'm going to go to Ben next, but just one quick thought on that to go back to Howie for a minute, realizing that there's more to it than Howie, to be sure. But if one steps back even half a step from the 4 prongs of Howie and asks the question, what was really going on in this case? At least as the facts laid out in the Supreme Court opinion indicate, what was really going on is some folks were putting money into an orange enterprise. And I think that sometimes take a step back or 2 steps back can just be a useful way to think about, all right, on some of those close calls, this factor, that prong, the other factor, how do you actually apply them in some of those areas where it's not so clear cut? It wasn't I'm gonna get access to orange groves, I've given you a bunch of money again so I can eat oranges, or I can do this, or I can do that. It was essentially to invest in an orange company enterprise, which I think, Lewis, goes along the lines of the point that you were making in terms of a common enterprise. Whether that is synonymous with commonality, maybe that's a separate point because of vertical and horizontal and what have you, but just in terms of what is this thing that one's talking about really all about. Ben.
Thanks very much. It was just something that Coy said that I thought was interesting. He was talking about how obviously it's not just the SEC that's interested in this question, that's going to have a say in this question. It's also Congress, and then Teresa was talking about how it's not just the investment contract in the definition of a security. There's a whole bunch of terms in the definition of a security in the federal securities laws, and it got me to thinking, well, if we're just talking about how should crypto assets be regulated, what should Congress do? Is it really the right thing to say that the CFTC, for example, should be the regulator of crypto? My concern there is the CFTC doesn't have an investor protection mission. It's not used to protecting retail investors, which would be fine if crypto wasn't being marketed to retail investors, but I think it is, which is why I think it, in lots of respects, fits within the definition of a security. But then, we were talking about the Howey test and all these things. It got me thinking, there's another possibility if, it would make sense for the SEC to regulate crypto assets, which is that Congress could just amend the securities laws to have crypto assets be part of the definition of a security. Do I think this Congress is going to do that? I do not. But I think it is, something that, should be considered when you're starting from this kind of like clean slate, when you're just asking this question, what is a security? What, also as Teresa said, what's the sine qua non of a security? To me, if you have something where people are it's marketed to people as an investment, it trades on exchanges, the value depends on what other people are willing to buy and sell it at, starts to look like a security, you can kind of then just ask yourself, well, should it be considered a security, putting aside Howey and investment contract and everything like that. And I just think it's a worthwhile perspective to consider. And I know that this is a question for Congress, but my guess is the SEC, its views would be influential in this respect. And then, again, talking about writing on a blank slate, the SEC could regulate it however it wants, right? I know there's a lot of questions about, well, does the existing disclosure regime, fit? Who's going to be making the disclosures? Things like that. I mean, the SEC can write a whole bunch of rules to come up with whatever disclosure regime it wants, both so investors can be protected and so capital formation can be formed. I just think that if you're really talking about this fundamental question, what makes up a security and how should we regulate crypto assets, who is the best regulator should really be taken into consideration.
Chris, I know you had a...
Yeah, this is like a 30-second. I really respect and really like the question of just sort of asking, well, who should be regulating what? I would say that even when it comes to this question of disclosure, I personally went to the agency many times to say, hey, why are we not updating, why is CorpFin not updating some disclosure rules? And I think that for those of you who are familiar with the concept of tech debt, that kind of builds up, there's regulatory debt. That's built up, and this entire process is sort of initiating the cleanup of all this regulatory debt. And assuming, and I think that sure, I mean the SEC has lots of smart people. They can address issues of crypto assets. The CFTC has lots of smart people who can tackle the issue. It'll ultimately be something that's happened in market infrastructure. But at the end of the day, we shouldn't just assume or minimize what that regulatory debt means in terms of any agency's regulatory competence. Thanks.
Yeah, I think, Chris, it's a really interesting point and a really interesting framing on an interesting point, and I think underscores all that is ahead of the commission, and I think underscores the value of you all having the chance to contribute to the discussion that we're having today. Sarah.
So, I mean, I agree on a lot of the discussion around we can't just rely on the Howey test, and that's just a function of there being regulatory debt, and that's why we want to do rulemaking. But in the interim, a number of lawyers and other advocates in the space put together an interim framework. I think the market would really be in a better place if we could start shuffling people towards better disclosure and better practices and have a target to hit. People that want to signal compliance still are not able to do so, that are already in the market. And so I think that there's things that we could do with knowing that we're not going to get it right with an interim framework with a sunset that looks sort of like another iteration of Safe Harbor 2.0, just to get some more herding of people in the market towards better practices. Because I think on the last administration, someone used to say a lot, an industry outside the regulatory perimeter won't long survive, and that was done on purpose. And so I think you could do really easily an initial sort of this market with a voluntary opt-in, and that's a self-sorting exercise right there, because if you want to continue to be a bad actor, you can vote with your feet either way. So there's that. And then secondly, I'm taking issue with, these analogies that the tokens are commodity-like, because tokens can be whatever the issuer wants them to be. I think you have to look outside that to the model. There are models where tokens are the only value accrual in a public permissionless network with open source software. Economically, those models will not work without the tokens as a value center. There's tokens plus equity, right? Those dual models. And if you raise money in the equity, as you raise money in the equity, your equity holders have more protections under law than token holders have. And so then you need to start being more careful of conflicts. And then we have like a public company potentially issuing a token as just like fundraising as a sweetener. And I think that in the context of the SEC's mandate, that we have to be very careful with investors, because tokens are in that stack, equity, debt holders, the least protected. And so the more conflicts your model creates, the more fraught it is.
Can I ask you just a quick follow-up, Sarah, just on that last, maybe second to last point on the stack in terms of traditional equity and then debt, and a company's capital structure can be quite complicated with lots of different kinds of securities or non-securities financing sitting within that overall capital structure. from your perspective, is it important, if one is going to consider a token to be a security, that one can situate it comfortably within a capital structure, or is that not so important, or is the view that if it is a security, if you kind of work backwards, then by definition it's going to sit somewhere because it's going to have some claim on the enterprise, and that then is going to be situated somewhere in terms of the seniority within the cap structure?
It sounds like we're back at what's a security. I just think that when I sort the market, there's securities on a blockchain, right? You slapped a blockchain on its security. There's crypto native assets that have functions that I'd like to see us optimize more for use than just trading. And then there's kind of digital pet rocks. And I think to collectibles, in-game assets, and I think like just that sort of initial broad sort, like I'd just like to focus on the tokens with use cases and how we kind of are letting, while protecting people, letting them actually be used and get into the hands of users and get network effects. That's sort of how I think about sorting the market, not, you know, how does this asset trade or stack up, you know, because that's like the financialization only of that asset in kind of a more fraught context. And I'd like to see the more pure models actually be able to proliferate and function, because there is no other value accrual center for them. They simply cannot function the way they were intended. They're being blocked by securities laws.
Got it. Lee, I think you were. I just have a cue that may not be in particular order, but I'm happy to go with John first.
Let me just go back to, I do have a point, but it's probably not related to Sarah's. To Collins' point before the break about, you know, vertical commonality, and obviously I recognize that is not, you know, in every circuit court a recognized form of common enterprise. Well, look, I am more than happy to concede if a protocol developer or issuer does not retain any tokens, then there is no vertical commonality. But I think we all know that is absolutely not what is happening when you look at these crypto protocols. I mean, look, if you truly cared about you know, sort of decentralization and kind of, you know, restoring sort of power to users of a system, you know, there's a 100-year-old model out there that exists called co-ops, right? Cooperatives. But the problem with cooperatives from the crypto industry standpoint is that your membership share is not freely tradable, right? So the whole business model of create token, pump token, sell the tokens we have doesn't work within the co-op structure. Another point I want to make goes back to Miles's point about the Commission's approach to crypto over the last 4 years was not conducive to the mission of capital formation, investor protection, and market efficiency. I mean, I would say it's not because of the Commission, it's because of, you know, the industry. Never before in the history of the United States have we had an entire industry, when told what the law is, say, no, we are not going to follow it. Now, I know there are people in this room who have genuine disagreements over how the Commission interpreted the law, but I think the reality is that the industry chose not to because it was not in their financial interest to do so. So let's just put things, you know, in perspective here. And my final point is, as much as I appreciate all this work, you know, the Commission has already taken significant steps in regards to essentially every outstanding enforcement action in the crypto context. So, and when you look at the filings in court to dismiss or pause these cases, it's predicated on, you know, the eventual outcome or the work of the crypto task force. So it does feel a bit as though this work has been front run, and this has real implications for the market. I mean, the day after one case was dropped involving a platform, we had, you know, CME decide that they were going to list Solana futures contracts, right? And Solana had been a named security in this case. And so, you know, there's already setting in place a form of what I say policy lock-in. It's going to be very hard to undo if the task force, you know, does come to some type of, you know, determinative conclusions here. But markets have already sort of reacted based upon the initial dismissals. So I think that's another thing to keep in mind as this work progresses, because the market is already responding to the commission's actions. They're not waiting for what this task force comes up with.
All right, so here's what we're gonna do. I'm gonna go through 3 or 4 folks. I'm gonna get some questions, and I'm sure there'll be occasion to come back to a few folks. I know that Sarah had a quick response to what Lee was saying, then I'm gonna go to Miles and a couple of others, and then we'll get to some of the questions from the audience. So Sarah.
Yeah, I'd say that, like, suggesting that all of those regulatory actions were good faith is a little beyond, like, credulity. Like, when being asked to register as an asset that got infected by an investment contract, like, there is a meme that went around, like, register as what? Register as what? I mean, the policy was constructed to keep people from a path forward. I know people that spent 4 years trying to find a path, negotiating all the way up to S1s, and they were blocked by it. And then, you know, the other example that I'll give was when being asked to register your staking business, and you kind of sort of looked at what securities laws disclosures, were those in the better public interest than just terms of service? They really weren't. And so those are just 2 examples I would give of just, we have been trying for years to find a path for compliance.
Miles.
Yeah, I think to echo Sarah's point, I think that it's not really fair to say that the industry has just decided not to comply. I think that if you look at you know, those that sought to come in and register, right, all of them went bankrupt. The SEC hadn't provided any guidance to the industry since 2019, even though the technology and the approach that people were taking had substantially changed, you know, every year, let alone over the course of 4 years. The process was not constructive at all, and what that really meant, right, is rather than the SEC actually accomplishing anything in terms of kind of investor protection, capital formation, or efficient markets, is what you ultimately did is you left lawyers like myself, Rodrigo, Sarah, Collins, right, to advise portfolio companies and clients, right, just based on 2019 guidance that really longer fit the industry. And when you're trying to advise startups, you only get to say no so many times, right? And when they, again, look across the street and say, hey, well, why is this person doing this? And you say, well, you know, based on, you know, 30 different factors that the SEC put out 5 years ago, it's a little bit difficult to get buy-in from entrepreneurs. So, you know, I would say that it was not that the industry decided not to say that they wanted to comply. It was that there really was no way to comply, and guidance was not forthcoming. Now, going back to Sarah's point, though, about she is right, that the digital assets are not monolithic, right? And what you're hearing up here on this stage is there's 2 extreme approaches. One, let's treat these all like securities. And the other one is let's not treat any of these things like securities. Neither of those are viable frameworks. They fail to contemplate or even look at what the risk profile of these assets are. They're simple. They're very simple. And as a result of that, they're attractive. I understand that complexity sucks. But at the end of the day, right, if we're not going to actually grasp what are the things that de-risk these assets, make them look less like securities, reduce trust dependencies, right, which helps investors, helps capital formation, helps efficient markets, right, then what is our actual goal, and what are we trying to achieve? We need to align the incentives of entrepreneurs, right, with the incentives of our regulatory structure, which is to reduce information asymmetries, reduce trust dependencies, reduce risk, okay? We can do that by giving them guidance that defines what the characteristics are that reduce the risk of digital assets. Failing to do so is just, you know, is just anarcho-tyranny.
Rodrigo.
Tough act to follow, but I mean, maybe just I'll respond to Lee's point, and then I'll try to make a suggestion for a clarification that I think the SEC could make that's important. I really have a problem with this notion that the industry was like a scofflaw and willingly breaking the law. I think it it doesn't take into account the fact that, as I maybe with too much detail described earlier, the law actually was not clear, and there were differing opinions about how the law applied, and it doesn't take into account the fact that there was no real path forward, right? So it was basically like the agency like pointing at the industry and saying, why aren't you walking through this wall? Like, we want you to walk through the wall, and we were like, we can't actually, right? So yeah, I don't think that's an accurate portrayal of the efforts that I think many of the outside counsel sitting at this table, people that were submitting rulemaking proposals, people that were trying to advise and engage with the industry and regulators were doing, right? Moving to something that I think where the SEC could provide more guidance and I think it would really benefit the market is really clarifying their stance on the third prong of Howey, with the profits from the efforts of others, right? As I mentioned earlier, I think it should be relatively uncontroversial that purchasing something with a profit motive in and of itself does not turn the whole transaction into a security. But turning into the kind of second sub-prong of that, right, like the efforts of others, I think the SEC back under Chairman Clayton really was on the right path here when in the statement when Gary met Howey, they described how Ethereum transactions on Ethereum were sufficiently decentralized to the point where those transactions were not securities transactions. And I think what that means to me is that at that point, the efforts of others, those others were dissipated to the point where there were no information asymmetries or the type of agency issues that I think securities laws are intended inherently to address, right? I think since that, the analysis has become muddled, and it has resulted both in like worse practices in the industry and worse information. I think the focus on enforcement actions that target developers or protocols that show any sort of value accrual to the token has led people to provide worse information to the market. People are worried to describe how a protocol might accrue value to a token, and I think it's also part of what's led to the focus on meme coins, right? I think, frankly, by persecuting a lot of the actors that were trying to provide tokens that actually accrued value, the industry responded by saying, well, here's, fart coin or like whatever, right? That clearly has no value. So I think I think this, reasonable minds can differ about this, but I think one key unlock would be to try to understand how protocols where, they're being sufficiently centralized or they're not controlled by any centralized entity can provide those revenues to the token outside of the securities laws. I think that is one of the key issues that has been holding back like the fee switch discussions around a lot of the key protocols in DeFi, and one where like if the SEC staff were to give guidance and clarity on how they're viewing that now could be really beneficial for the market.
Can I just have one quick follow-up for Rodrigo, and then John, I'll come over to you. Just the very quick follow-up. What about the measurement practicalities, right? So one of the things I think when the discussion, it is not unique to crypto assets or even Howey for that matter, is you have to go from concepts or principles, as we were talking about earlier, to actually figuring out, all right, well, how do you measure if in the particular context of an asset, particular context of a transaction, in particular context of a market participant, whether it's an issuer or what have you, whether or not that thing, whatever that standard or that principle is, has been met, right? So all concepts, all principles need to be applied, and with that application, there becomes what, just to my mind, to put it very simply, is a measurement, just question and then challenge. To put it a little differently, there's always the, well, how much is enough, or how much is too little, and by the way, how do we measure that? So on some of the things that you were mentioning that you think would be helpful, do you have a sense or suggestion for how some of these concepts could or would or should be measured in practice?
So I mean, honestly, I don't think I have the answer to this. I approach this with a lot of humility and the understanding that it's going to take, groups like this to try to fine-tune the language, and then that language to be tested over a bunch of cases and figure it out. But I think the principles should be relatively uncontroversial. It's just because you're buying something for profit, and if that profit is not being derived from a promoter that's sitting back there telling you they're going to do things, but rather from a distributed group of people or a distributed network, moreover, particularly one that's not controlled by anybody, I think that raises fundamentally different issues than the securities laws were intended to address, which are agency problems and information asymmetries.
Yeah, and humility is a is a good thing.
I think to the point that you were making though about like the economic value that is accruing to the token, right? I think that like a clear delineation, right, would be, is that value accruing based on the programmatic functioning of the network, right? Or is that value accruing to the token because a company's taking its profits and putting them back into the system by buying the token and burning it, right? Like, so there are pretty clear lines of delineation that you can make, right, around whether or not this stuff is happening programmatically or whether or not a human is kind of in the mix.
I think,
John, Collins, real quick,
Oh,
and then
yeah, I was just going to say, I think to maybe one concrete suggestion as well is, I think starting with maybe the framework that we've used for previous regulatory exemptions with a rebuttable presumption and establishing certain thresholds for that rebuttable presumption is probably a safer route than trying to come up with, let's say, thresholds that will make a definitive determination. But I think when we look at a rebuttable presumption, using one of the examples we were talking about before, I think, was it Lee, or I think it was Lee, talking about maybe what does it need to look like if a common enterprise is established. We might start with a rebuttable presumption of under 10% holder, maybe a rebuttable presumption that there's no common enterprise. It doesn't mean that the government can't then come in and say, hold on, we're looking at affiliate relationships, we're looking at something else, and in the aggregate, we actually think this doesn't apply. But I think starting, and I think I get the sense that everyone's worried about setting a threshold and then later we find out it's too high, it's too low, but I think that the solution to that is setting it as a rebuttable presumption rather than a hard threshold is probably the initial place to start there.
yeah, I want to come back to that after John. In that, one, I think it's a really important point, and number two, there's some questions that other folks have submitted from the audience that speak to that. So it's going to be a great segue to some of the questions that we've gotten. But John.
Thanks. This goes back to this notion that someone brought up about caveat emptor being a bad regulatory paradigm, and I agree with that. I can't remember which panelist said it, because there are two critical omissions that I think are very important for everyone to consider, and I really hope the Crypto Task Force will consider them. The first are the externalities associated with crypto. They cannot be denied, and they cannot be overstated. Drug dealing, human sex trafficking, child pornography, terrorism, ransomware attacks. I'm a ransomware expert. But for Bitcoin, there would be no ransomware. Lee and I teach at Duke University in Durham, and Colonial Pipeline was hit with a ransomware attack. And at that point, there was no gas in Durham. You couldn't get home from the airport. I mean, it started to get kind of scary. I've met with the FBI on numerous occasions to work out, to find out if there's any way that people can get their ransomware payments back. I write extensively in my statement why crypto is not traceable. You might be able to find where it is, but you know how much ransomware payments were ever recovered? Pretty much none. Occasionally you get lucky, you find some, you know, in a laptop, in a popcorn tin, under a blanket, in a bathroom like they did in New York. But again, I go over this extensively in my prepared statement. Just think about last week, $1.5 billion, the greatest financial heist in the history of the world. It was crypto taken by, it looks like, North Korea and used for their weapons program. Now, everything that I just listed, you know, there's always people who say, that's just not true, John, and fiat is much worse. It's just not, those points are really false, because if you look at every government report on this idea of the crypto crime wave, and I just think that the Crypto Task Force should consider that. And then there's never really been a check of systemic risk associated with crypto. When Voyager, Celsius, BlockFi, FTX, when that big crash happened, it didn't really impact anyone too much. You know, there were safeguards in place because the FDIC, the OCC, the Fed had all pretty much said to any bank that does anything having to do with crypto, and this is what the industry has called the chokehold, said, you better prove that to us, and it's going to be an indicator, it's going to prompt an exam, it's going to prompt scrutiny. Now, all of those, from what I can read, I'm not a banking expert, all of those guardrails are now rapidly disappearing. So if you look at, I was here at the SEC during the subprime crisis, and you might say, well, subprime, what does that have to do with me? I'm not going to take one of these silly subprime loans. Well, it impacted everyone. Or Enron, WorldCom, HealthSouth, when all those crashes took place. I was here at the SEC, And again, you might think, well, what do I care? I don't invest in those things. But that impacts everyone. And you really, when you look at that systemic risk, a friend of ours, Hillary Allen at, she at AU or AU, wrote a book called Driverless Finance. And I would recommend that everyone read it. And another guy named Arthur Wilmarth wrote a similar article about the systemic risks involved. And I'm a big Wizards fan. For the last 12 or 15 years, I had season tickets. And I was at the game the other day in the elevator, and I'm talking to two of the security guards who know me, and they're like, Mr. Stark, I saw you on 60 Minutes. And I said, oh, yeah, I was on. What'd you think? And they were like, I just saw the end. You said something about crypto. And I said, yeah, it's a really dangerous investment. And they're like, really? We both invest in it. And I said, okay, should we stop? And I said, I'm not telling you what to do or not to do, but what do you think you invested in? And they had no idea. No idea what they had, and they laughed about it. They're like, I have no idea, I just heard it's a great thing. The power of FOMO, the power to turn the victims into victimizers is very serious. And so, when this, if it does cause a systemic crash, it's, ask not for whom the bell tolls. It tolls for thee. We will all be impacted. So I think these are important considerations for the SEC, and I think the idea of caveat emptor sounds nice, and I'm a libertarian myself. I totally appreciate it. But if you read the Celsius pleadings, you can read all the victim statements, and I have. And it's heartbreaking. It reminds me of the 20 years I worked here. You can say these people, they took it on themselves. They took this risk themselves. They knew what they were getting into, and they didn't care, and that's on them. Well, everybody lets their guard down every once in a while, and that's just the wrong approach to take toward victims. We all get duped. You all let your guard down. So I hope the task force will consider those ideas when they're trying to figure out whether this should be part of the SEC's mission or not.
All right, well, I was going to pivot, but I'm not quite going to pivot because I got a lot of folks getting my attention, but I'm going to pivot in 5 minutes, so everybody's going to make this quick. So Sarah, and then Chris, and then Teresa, and then I'm going to pivot us a bit, and then I'm sure we'll come back to some of these themes.
So I would just quickly respond on the last point that those institutions that you named, I think that's a symptom of being forced outside the regulatory perimeter. And what you are naming are centralized intermediaries. And a lot of that fallout was from counterparty risk, which is a risk that is inherent in TradFi. And there's actually some studies that DeFi withstood contagion risk. It was one of our first studies that we saw that it actually can break contagion risk. So as a structural counterbalance to traditional systemic risk, that would be something to lean into. But given the size of the relative markets, it's a who's locked in here with who. TradFi is likely to be the risk source that creates contagion for a much smaller nascent market.
Chris.
So just to piggyback off of that one point, I was about to say systemic risk is definitely something that regulators have to worry about. Certainly, I think banking regulators, to your point, John, will have to tackle in particular, but also to the point that the vectors for that systemic risk, if not, the TradFi will be just more the centralized players, and therefore you have to ask questions about interconnectivity. But I was only going to speak because of the caveat emptor point, which I brought up, so I said, okay, let me go. What we've ultimately had over the last several years is an idea of we're not going to regulate, and because if we do, it's somehow going to add some kind of legitimacy to the market. So we're going to sacrifice our little lambs here of investors who may get duped or something, but we're not going to lean in. And I don't think that that's a sound regulatory strategy. I do not believe that caveat emptor is a regulatory strategy. It does also, as the point I made earlier, it creates regulatory debt. It just creates a void, and it gets messier and messier and messier to clean up. And that's why we're here today, and that's just, from observing things from across the street.
I don't disagree, Chris, but I'll point out that caveat emptor was the logic behind the recent statement that meme coins are not securities.
There are several forms of regulatory guidance that I think are necessary. Admittedly, when you have the absence of defining where at the top of the funnel in general the regulatory approach is going to be, I think it does make it problematic and difficult. I have to admit, we've had a very wonderfully busy and active SEC, so I haven't read like every single thing, particularly in the last week that's come out.
To quote Commissioner Peirce, don't go running to mama government if you lose a fortune on the Trump coin. So.
I mean, I wasn't going to get into like meme coin and what's a definition, but again, it does. I have no idea what's particularly into the meme coin thing, but certainly, if the expectation of profits prong is a big question in terms of what's defining, and if you're really, really curious, what defines a security. If anything, I have said with people that you and I both talk to very frequently, that is a challenge for trying to classify a meme coin in and of itself, not tied to a larger transaction, but in and of itself. If there's no expectation of profit, it's kind of hard to pin Howie there. I do want to reiterate a point that Rodrigo made, which is incredibly important, which is just because you want to invest your money doesn't make it a security. And this goes back to, and I can't believe that what I said at the very beginning of this place is actually going to be important. I was just trying to buy my time. But when you think about like why securities laws exist in the first place, it's not to say, notice that there are 4 prongs. There's not 1 prong. It doesn't say if you have an investment of money, you're a security. It says nope. It says if there's an investment of money, continue now to the other prongs of the Howey test, right? And securities law and Howey test is very clear that you must have all 4 of those features, even under Howey, and in order for securities laws to kind of kick in. So that was a lot more than I thought I was going to say. So I'll just be quiet and let everybody respond.
All right. So thank you, Chris. Here's what we're going to do. So Teresa, but then I think Coy, you may have tried to get my attention. Collins, I'm not sure if you were still trying to get if you wanted it. Yeah. All right. So Teresa, 1 minute, if that's okay. Coy, 1 minute, if that's okay. Collins, 1 minute, if that's okay. Through the conversation, we're hitting on a lot of the topics that have been offered up, and then we'll take it from there. So Teresa, Coy, Collins, and then pivot.
Okay. Feel free to interrupt me, okay? So with all due respect to my friend John Stark, who I also was at the commission in very difficult times like post-Madoff, and none of us are in favor of victims, and I think everybody here is against victimizing people in any kind of way. And I do have to push back a little bit about no ransomware without Bitcoin or crypto, because I do believe that there would be a lot of ransomware continuing, just like there was ransomware before Bitcoin, that it will continue with or without Bitcoin, and that people do bad things with lots of things. So people do bad things with crypto, they do bad things with fiat, they do bad things with paper, all sorts of things. But just because they do bad things, it doesn't mean that you outlaw it, or it doesn't mean that you ask the SEC to step outside of its statutory authority and become the overbearing mama government to take care of everybody and protect them from everything, because that's not, they don't have the statutory authority to do that, and doing that would actually be breaking the law. So I'm really cautious about asking the SEC to step in and do these things when they do not have jurisdiction. And I also caution the fact that, look at all these people, we're all pretty smart, right? And there's lots of smart people who have been talking about this for years, trying to figure out how are we defining these things? Because just because there's a problem and planes are crashing doesn't mean I want the SEC to now try and take over for the air controllers, and so I think the fact that we've been dealing with this for such a long time, it shows how complicated it is, and it shows that we really need to dig in so that the SEC isn't acting outside of its statutory authority. And I really applaud what they're doing and coming out with things that are like so clear, like memes, right? Things like that, where it's like, this is not a security. And there's only so much they can do, because there's an executive order out there that says digital asset industry plays a crucial role in innovation and economic development in the United States and our international leadership. Like, is the political question doctrine now being invoked? I don't know. Does this change the major questions doctrine application in courts? Maybe. You know, it's like there's so many bigger things here that I think we need to think about and not call on the SEC to be the, you know, overarching to fill in any kind of hole somebody might see with fraud. And there's other regulatory agencies that might be better suited for some of these things. And I mean, fraud is still fraud. You can't lie, steal, or cheat. That's it. With or without securities laws. Can't do it, it's illegal. Somebody can come and get you for it.
Coy.
I'm largely in agreement with Teresa, maybe just to put a couple finer points on it. I really would urge the SEC to stay focused on its mission. Some of the issues have been raised on systemic risk. The SEC is not tasked with looking at systemic risks. FSOC exists for that purpose. If FSOC wants to look at it, they're certainly welcome to. For what it's worth, FSOC has looked at crypto assets since probably at least 2018 and hasn't really seen a big problem with it to date. With respect to anti-money laundering, sanctions concerns are very valid and real. The SEC has a very narrow jurisdiction in that space for registered entities, and they work together with FinCEN, and they work together with OFAC. So I think obviously focusing on that, if those registered entities are allowed to engage with crypto assets, certainly makes sense. But otherwise, I would just urge the SEC to stay focused on the concerns with crypto within their jurisdiction.
Collins.
Yeah, just really quick. I think on John's point, I think I might actually break with a lot of the people that I think consider me on the pro-crypto side, and that I actually agree that a lot of the negativities and the fallout are some of the most pernicious things that our component of the industry kind of produces. But even with that said, I think a lot of the times crypto critics get into this mode where they're making actually genuinely great points, and then they hyperbolize to the point of like disbelief. And like one of the things is like the first set of ransomware occurred in 1989. If any of you all were on LimeWire back in like 2005, you had your computer locked with ransomware. All of those things did exist. So I think it's definitely a valid point. And I actually will not go to the point of saying, oh, well, other people do it and it's just as bad. I actually do think we have a unique problem within the industry, but I do think that it severely undermines a lot of our crypto critics' points when they jump to this weird hyperbole for things that it's not necessary. And this gets to the second point, which was on Lee's point, the meme coin guidance wasn't based on caveat emptor as the logic. It was, yes, a warning to people, you should be aware that these things are not under the protection of the laws. But the premise was based on a Howey analysis. It was that you didn't have this investment of money in a common enterprise in any of these meme coins. To the extent that you do, or you use meme coins for those investment transactions, you're still subject to the act. So again, I think you guys both raised phenomenal points on those, but it's weird to mischaracterize what's occurring when your points are already really, really valid. And I think it's a bit strange.
But, you know, ask any cybersecurity attorney, but for Bitcoin, there would be, you know, ransomware. Ransomware back then was maybe $25 gift card. Now it's $15, $20 million payments, and it wouldn't happen without Bitcoin. The FBI will tell you that, DOJ will tell you that, and you can come to my conference on April 22nd where we talk about all the different types of cybersecurity and have a ransomware panel, and every single person on that panel will say, but for Bitcoin, there would be no ransomware.
Do you know
That's
how much
not
the
hyperbole.
first ransomware amount was for the AIDS Trojan?
Pardon me?
Do you know how much was in that first ransomware attack in 1989?
No.
There were 90,000 floppy disks given out, and it was something like $25 to $50 each. It was already a couple $100,000, first attack. So I'm not sure where you got that from. Now, I agree, like 10, 15 mil more, absolutely, much higher. And that's why
It's
I say
all
I actually,
Bitcoin.
But
Every
from
ransomware attack right now is
1990
Bitcoin.
From 1990 to 2005, more than $30 million of ransomware attacks happened. Now it's been substantially higher. And that's why I say it's absolutely right that we should be focused on that in crypto in particular. But it's weird to say, oh, like Bitcoin invented this, and if Bitcoin stopped existing.
So I'm sorry, just going to jump.
He didn't say Bitcoin invented it, and I totally agree with you. It obviously predates Bitcoin. But, you know, a few years ago, FinCEN issued a report tracking ransomware-related SARS filings. Okay, and so if you look at that report, every single, and obviously that's a subset of the, you know, every ransomware payment. So, but at least every single SAR filing tied to ransomware, the ransom was paid in crypto, mostly Bitcoin. Your second one, Collins, on the meme coin guidance, I actually do agree with you, by the way. So obviously, if you read the guidance, it's grounded in Howey, which, and frankly, I agree. Like most meme coins are not securities. I didn't think it was actually necessary to say that in staff guidance. My understanding is that the reason that was put out was to serve as a warning, and I believe Commissioner Purser, you know, correct me if I'm wrong, you know, had a accompanying statement sort of along those lines, saying like we are here to tell you that if you lose your shirt in a meme coin, don't come crying to the SEC, right? So that's, so I agree with you that it's certainly grounded in Howie, but the intent was to warn the public.
I just wanted to maybe just see you, Collins, and raise you one, because I also agree with John that it is a problem. I agree with you. I think the problem is not, the question is not, is it a problem? It is. The question is, what is the solution? And I think sometimes those who, they say forget history are condemned to repeat it. What are we going to do about this? And it sounds like from all your writings that your goal is let's just try and eliminate any crypto anywhere we can find it. I recommend a book to you called Last Call, The Rise and Fall of Prohibition. It's a great book because there were many, many problems prior to Prohibition. It was a pernicious problem. It was a legitimate pernicious problem. And the attempt by the government to tell people don't do something you want to do failed miserably. So I don't disagree with you, John. It is a problem, but just telling people and wagging your finger don't do it ain't going to be the effective means.
All right, so let's take that as the opportunity to think about a bit of a pivot here. But one of the things that was interesting from my perspective of the conversation is, at least as I've been deciphering, is there are just different views and perspectives as to how to approach the what is it question. And I think we've seen that for the last 20 minutes, and I'm not sure we're going to solve that today. I certainly don't have the solution to that. Tall order for the commission, but I think it's illuminating just through the conversation and the back and forth to see that some of this isn't just about nuances around how does one interpret or apply this prong of Howie or that phrase within the broad definition of security under the 33 Act or the 34 Act. They are just very different views as to what's the right frame, what's the right question, what's the right lens to put on the is it a security or not. And I think it comes back to the work that the definition does in terms of figuring out, does the SEC have jurisdiction? Or, picking up on a point that Teresa alluded to, if not the SEC, who? Because somebody else is going to have jurisdiction. And then that may relocate some of the discussion to say, well, but do we think they have the appropriate authorities? Interesting whether or not that discussion is one that ought to inform the threshold question as to whether or not the SEC has jurisdiction, or if rather that's a discussion as to that agency and those authorities and that legislation and that regulatory regime. So it's been interesting for me to see all of those points come forth, because I think that the best way to figure out what the path forward is, which is the pivot I'm going to make, is to have all of that surfaced. And so at least everybody understands the different perspectives that are being brought to bear. One, that's the best place to see where there is commonality, where there may not otherwise appear to be, or just see where there are genuine differences and the reason for those differences. And then ultimately, policymaking is about making choices and judgments about what the right way to proceed, and of course advising clients is about making judgments as well about what it takes to be compliant. So with all of that, here's the pivot, and again, a lot of what the discussion has indirectly spoken at least to a number of the comments that and questions that have come in. But I wanted to pick up something, and I think, Collins, you were making reference to it a couple of comments ago, and some others were as well. I want to very much keep the discussion focused on the purpose of this roundtable, which is what's a security, or crypto asset securities, and when and which ones, and not turn this into a discussion about substantive regulation. So with that cabining of us, I do think there's an important question. And again, Collins, it comes back to something you were saying, but I'll just open it up to the group. That's this. One of the, I think, and we've heard this today, I think, challenges with the lack of clarity for some. Some people think it's clear, others think it's not clear, but for the lack of clarity as a lot of people see it in terms of whether or not a particular crypto asset is a security or whether or not a particular transaction involving said asset is a securities transaction. I think part of it as a practical challenge is, all right, well, but if it is, then what do I do? And so just a very practical question of, all right, if this is a security or this transaction involves a securities offering, what have you, secondary transaction, well, then what? And then the practical challenges when it comes to compliance with what the natural implications are under the federal securities laws if you have securities and you have securities transactions. Because if you do, you got to do a bunch of stuff. And the question is how do you do all that stuff in a compliant way, going to Sarah's point, given the nature of the underlying technology? So with that as a backdrop, and just mindful of the different views on the is it a security or are they securities and when question, to what extent indirectly can some of the difficulties and challenges and line drawing and measurements and what have you that go to the definitional question indirectly be resolved through the substantive regulation or pathways that actually speak to say, well, at the edges, we may not know for sure if it is or it isn't security, but at least what you have to do, we're going to tell you what you have to do under these circumstances. Does that alleviate any pressure? And again, I don't want to turn it into that substantive discussion. What might that look like? But does that alleviate any pressure on trying to get it exactly right, given all the different competing perspectives on what's a security in the first place? I don't know, Colin, since you kind of inspired the question, I'll start with you.
Yeah, and I'll be quick. I think it will. I think it won't resolve all of the issues, but to the extent that there is something like, let's say, an exemptive framework that says, okay, when you have a securities transaction, you operate in X, Y, and Z manner, these are the disclosures that's required. I think that would solve a significant amount for folks that are saying, all right, well, I can just opt in. And the reason why I know this is because when 2017 or 18 happened and SAFs came out and then fell out of favor, a lot of folks in the U.S., SAFs are still being used outside of the states, but you actually found a lot of people started inherently structuring their offerings as Reg D offerings just prophylactically. Obviously then, subsequently, I don't think it's the current case, so we can mention it, the Telegram order came out, and that actually undermined a lot of people structuring that way because they thought, well, I can do a compliant Reg D offering, and then at some point when the thing is not a security, I can move forward. That obviously was taken away, and I think to a certain extent that was arguably understandable in that context. But to your question, one model is the exemptive framework then reduces some pressures from folks that say, look, I can operate in this non-security or securities law context, I'll just be compliant. And we already have people trying that now. The other thing is on a registered pathway, if you could, even if it was just as simple as saying, hey, here are the things from Reg SK to here that we want to see, absolutely. Then all of a sudden you have people saying, all right, well, great, I can go and register because now it's not that I have to produce audited financials or something, it's that I've got to have my open source code available and something else. So I don't want to, like you said, I don't want to get into the details. I think the primary focus is if you provide pathways, there are already people that are trying to do this, and they're saying it's not about not identifying people. Like I already have people that I KYC, I know all of these people, I have the relationship. The only issue is I can't figure out what I'm supposed to do with, let's say, an audited financials requirement where, what am I going to report, the protocols revenue? Do I do something else? These are the practical things that without guidance, no one could register even if they wanted to, and folks have wanted to.
Teresa.
Yes, I think there are some things that you could do, and particularly the 33 and the 34 Act, the 40s Acts too, but I'll focus on 33 and 34 have very broad exemptive authority with regard to securities, security, transactions, people, classes thereof, and not only to exempt them, but also from any part of those acts, as well as conditionally or non-conditionally. So there are a couple of approaches. So if this question is so, we can't really get to what the security is, you could frame an exemption as something with these characteristics, are not a security, or these, and you could basically narrow the definition of a security through the exemptions. And that is a bigger kind of use of the exemptions than we've seen, but that is something that Congress specifically and purposefully gave. And I believe that it also you can exempt people from every part of the securities code so that it doesn't have any impact of the securities law. So that means 10b-5, that means Section 17, not just registration, but everything. The private right of action is really, it's judicially created. And so if you look at it from that way, you have to justify it as being consistent with investor protection. But consistent with investor protection, I think we've seen the negative impacts from having something all of a sudden a security. The real losers there, the people who lost the most money, were the people who own the asset. I don't know that that was really consistent with investor protection. And so I think you could do that if you come up with something that you think should fall outside the securities laws. It doesn't mean fraud's okay, because we still have fraud. It just means we don't need to modify our fraud laws so that, the efficient market hypothesis is baked into the fraud requirements such that there's no reliance, and fraud is like the fraud on the market. It's assumed that the fraud is within the price of the asset, and so it's basically modifying a little bit of that liability issue. But fraud is still fraud, and fraud is still illegal and can be brought out, or people can be prosecuted for that. And then separately, you could also come up with some sort of exemption for things that are securities, but you want them treated a different way. And that's when you utilize the conditional part of it, right? And so then you can have the exemptions and then condition, certain types of disclosures, like more like a licensing kind of thing if you want, or Reg CF is a great example of something like simple, basic, somebody can do it for maybe like $5,000 or, and that kind of a disclosure, and you can file something, and as long as you are able to, as long as you actually have asymmetry of information, and there is somebody who can disclose it. And then just like Reg A, you have, Form Z. So here you could just say, well, I don't have enough of my, I can't make any more disclosures. I don't have information. Here's my form, to depart. So I think that there's a lot of different tools and a lot of different things that we could use the exemptive authority through. And fantastic economists here to go through the cost-benefit analysis, I think. And so I do see that could be a pathway.
Yeah, so let me pivot to another topic, just keeping track of time. We got 15-ish minutes left, ending a little bit before at the top of the hour. So maybe one or two people per each of the next. I know there's so much more that folks want to have a chance to share, but we don't have time for everybody on every point at this point. So try to keep it to one or two folks responding. Coming back to some of the questions that we've gotten, I don't think the topic of fungibility, NFTs has at least expressly come up today. I'm curious if anybody wants to share a thought in terms of how to think about what people refer to as NFTs and the ways in which fungibility does or doesn't map onto, Howie or other aspects of the definition of security. Any takers on NFTs, fungibility? Looks like Lee has a thought.
John's volunteering me.
Looks like John is volunteering.
Yeah, so I'll just note that I do have a section on NFTs in my statement. I mean, not that I'm a NFT connoisseur by any means, but look, I mean, I think it's probably true that most, at least the ones I've looked at, are probably not securities, not investment contracts per Howie. But again, it's facts and circumstances dependent, right? And it's clear that some are, and obviously I know Commissioner has been dissented on several NFT related enforcement cases. But back to my point at the way back when. There's also private litigation, and there was a case. Hopefully, I'm allowed to talk about cases not SEC enforcement related, but Harper versus O'Neill in the Southern District of Florida, federal court, Federal Judge Moreno, looked at the facts and circumstances around a given NFT and said that they did meet the definition of an investment contract. So again, I don't have like a blanket statement to make, and I guess that would be my recommendation to the commission is. Unlike the meme coin guidance, I would highly discourage you from considering putting out some type of broad guidance around NFTs, because again, it's always going to be facts and circumstances dependent.
Miles.
Yeah, I mean, I generally agree with you. I think that it should be a facts and circumstances analysis. I would say that one thing I would highlight is that I think that the Commission's actions against some NFT companies is actually evidence of how politicized, the agency's approach has been to the industry. There are tons of examples of video game companies that sell assets within those games prior to those games being launched, and they fund the development of those games with the sale of those games. Now, just because those digital assets are not cryptographically secured on a blockchain, they're somehow not security transactions, but NFTs sold on a blockchain are security transactions. So I think it's very important that the agency kind of steps back and looks at the economic equivalent transactions that are taking place in ordinary commerce that have not been treated like securities transactions and reevaluates its criteria for assessing the securities laws application to NFTs.
One of the other topics that we got a few questions on, we talked about it a little bit earlier in the day, is on secondary trading, as compared to, I'll call it primary issuance, although I guess to use the word issuance is to, in some sense, conclude the answer to the question that's being discussed today. But I'll use it in the general sense. I'm not going to use it in the is it an issue under the federal securities laws sense for purposes of the question. But I know there's a lot of thoughts, and I know that there has been a lot said over, well, even if something is a security upon quote unquote primary issuance, if you allow the use of the word generally here, that when it comes to secondary trading, perhaps not. I think that actually dovetails back, Louis, to the point that you've written a lot about, which is say, well, wait a minute, to say secondary trading versus, say a primary issuance begs the question of what? What is the primary issuance of versus what is the secondary trading of? And is it a primary issuance that is, say, an investment contract where the token is something different, disaggregated from the investment contract as such that when you have secondary trading, if it's secondary trading of the token, but the token wasn't even the security when it came to the primary issuance, then how could the secondary trading actually be a securities transaction because it wasn't a security at the primary issuance? That requires the sharp distinction between the investment contract on the one hand and the token or crypto asset on the other. But it is something that I think folks sometimes wonder, well, wait a minute, how can I wrap my mind around it was and then it isn't, but maybe it is, but maybe it will be in the future? That's the broader point in terms of things can change. But specifically on secondary transactions, Louis, I'll direct this one to you. What are your thoughts?
So I'll certainly be brief, Lord knows. But you're right, Troy. I think there's been a little bit of heat here on this topic, and I'd suggest maybe turning down the heat because there's some really just practical questions. What difference does it make? Let's ask ourselves that. What difference does it make? I think there's broad agreement, as you alluded to, Troy, that regardless of what the asset is, if there's a fundraising transaction that meets the four prongs of Howey, it falls within the securities context and either should be registered or exempt. And then you have something that probably by itself does not meet the four prongs of Howey, and it's being exchanged. So if it were to be treated as a security, as has been suggested we should, how would that be different in a secondary market? And so the first question is it need to be traded on a national securities exchange or an exempt alternative trading system? That would be one implication. If it was a security, it would be. If it was not, it would not be. And so we just need to ask ourselves, if we are going to treat perhaps quite a lot of tokens that would appear to be subject to some level of control, then they would need to be traded on national securities exchanges or alternative trading systems, or not traded at all in the U.S. So we'd have to cross, that bridge. And then the next question would be, what about all the other rules that apply to secondary trading, in particular things like the Williams Act and otherwise, in terms of aggregation of information and control? Those things don't currently apply to crypto assets that are not securities. I would say that, a thoughtful regime that tried to figure out how to kind of apply those in a way that made sense for crypto would make sense. You'd also, if in secondary transactions the tokens were widely held, you'd at least ask the question, should there be general disclosures that are on an ongoing basis? One of the reasons our equity markets in particular work so well in the United States is because we have very, very clear and firm rules about periodic disclosures, including current disclosures, that allow the markets to address information. And I would say, Troy, that I would also strongly endorse such a system to be adopted. That, unfortunately, is likely mostly the realm of Congress, but we would see that. So I think secondary markets, it doesn't need to be this sort of high-level OMG kind of situation. I think there are practical questions, and they have practical answers. So, yeah.
One of the points that was made earlier is, Teresa made a reference to the point that if you look at the definition of security, turns out there's more than just investment contracts. And I know the Commission is very well aware that there's more to it than just Howey and just investment contracts. Of all the different phrases, words, types of securities that are within the definition of security, whether you're talking 33 Act or 34 Act, which is particularly what we're, I think, contemplating, even though it turns out there's more than the 33 and the 34 Act of the Federal Securities Laws. I think kind of what's in folks' minds is primarily the 33 and 34 Act, at least today. The other type of security that gets the most attention, though it is a distant second to Howey and investment contracts, are notes and reeves. And so I'm curious if anybody wants to speak to kind of the practicality, as a practical matter, right? Just set aside legal questions and what have you, and the Reeves test is interesting because the fourth factor of Reeves is essentially, does anything else reduce the risks that otherwise the holders of the notes would incur? So it's an interesting fourth factor in terms of just a jurisprudential construct, very policy-oriented, going in part to the kinds of things that Lee and John were talking about. That's expressly in the jurisprudence of Reeves for purposes of notes. It's not there expressly in the jurisprudence of Howey, insofar as Howey is articulated by the courts. But with all of that, as a practical matter, is there much consequence of whatever uncertainty, lack of clarity around whether or not a particular crypto asset is a note, or is that more of academic interest, but in practice isn't something that has much consequence?
Yeah, I think the note analysis comes up most often in a staking context. And so the different, I think it's the different types of transactions are oftentimes, where these come up. And I kind of, the way that I think about this is thinking about, like, what are you actually getting and when is that transaction over? And, it's been very clear for the most part until now that when you get something, it's done, right? Now, what you get might be something else, or so like with the note, for example, it could, there's the note transaction, and then when you're getting paid your interest is, are you getting paid, and is that a security, right? Like normally, no, that's it. But then to continue to treat what you get back, treat your interest as a security, then that's a separate analysis. Just like in Howey, when the use of proceeds, when you get the token, usually like in a SAFT, I give you it's clear. I give you my money, you're in, and not to go back to Howey, but just to kind of explain how I'm approaching it with all of these things is, that's the capital raise. I'm trusting money to somebody in both ways, in both notes and investment contracts, and they're developing something. I'm promised like their efforts, and I'm promised the proceeds from their efforts, and the proceeds of their efforts is a token. That's it. Thank you. I got it. To me, transaction over. But is that, whether in a note context, profit type of sharing, or investment contract, or all these different things that it could be, then the question becomes, is that thing that I got, is that now a different type of securities transaction? And I think that's kind of where some of the analysis is getting conflated.
John.
Yeah, I agree with that. I think that it's always going to be this facts and circumstance test. If you look back at prime banknotes, remember those? Our office did a lot of those enforcement actions. These were bogus instruments that purported to represent a secondary market for standby letters of credit. Huge mouthful. Some of them just paid 1% above prime. Some of them were much bigger. It came over from Europe. They dominated, especially on the internet. The fraud was everywhere. And when we sued them, when the SEC sued them in a case called SEC versus Lauer, they asserted the SEC doesn't have jurisdiction because these instruments are entirely fictional. So how can the SEC have jurisdiction, right? So I think, I can't remember which circuit court it was, but the court came back and said, look, if it were true what they purported to be, then this would be a security. So the SEC had jurisdiction over prime banknotes and was able, by bringing all these cases, to essentially eliminate that fraud certainly from the United States and maybe even further at the time. So I look at it sort of like Teresa does, as sort of facts and circumstances.
Corey.
When I think of the notes and Reeves analysis, I think this is maybe a good example of where the task force could look in terms of staking, of providing clear guidance when a lot of staking services I don't think really meets the Reeves test. And I think if there's a way to get comfortable for the task force there, that'd be great. But I also think of it in the lending context, right? I think that's where the SEC has successfully brought some charges. And I just flag in the context of there's not many centralized entities doing crypto lending out there, but one of the many travesties of the last 4 years of the SEC was the settlement against BlockFi that told them
No names.
Settlement against one issuer of a lending program that said, come in and, you can come in and register, but by the way, there's an Investment Company Act problem and you have 6 weeks to figure that out. And then 6 weeks came by and it never got figured out. Like, if there has to be a way to move forward if you're going to tell people to come in and register. So I just wanted to plug that.
And then, is that Collins or Ben?
Yeah, just on Teresa's point, I know she mentioned staking, and I think Coy just kind of alluded to it, but separate from like centralized crypto lending, it definitely would have a very significant impact on clarity for DeFi. There are several structures that we deal with that actually don't look like investment contracts. They actually look like they may, if they were to be analyzed, be more under the note context. And that again has substantial implications for, one, the default being most treatment of notes, treat them as debt securities. That comes with a whole host of implications that aren't applicable to equity securities. So that distinction alone ends up informing a lot of the downstream regulatory impacts. And then just a question for you, I don't know if maybe this is the right time or hopefully somebody else has brought this up, but other categories like profit sharing arrangements or participation in a profit sharing arrangement is actually something that I'm actually kind of curious to ask the SEC folks about, because it's been one of those things that I actually think tends to pose more of a challenge if the SEC were ever to raise this, because some folks say we just look at that under the Howey analysis, but in canvassing case law, it's actually there's very, very little case law about what constitutes participation in a profit sharing arrangement. And being frank, a lot of the stuff that we've talked about, a lot of stuff we deal with in DeFi, that probably seems more of a relevant thing to get clarity on. Now, if the answer is we're just going to use Howey, great, it's easy, but it's actually never really been clarified. And I'm wondering if you have a question on that, or maybe somebody here could tell us that. It would be fantastic.
I never did speak on behalf of the commission, and I'm still not speaking on behalf of the commission. Let me just make one quick comment on that, and then I'm going to come to Chris, and then we may be at time. But I think the point is, and it underscores a point that others have made, is an important one in the broad sense of the definition. Right, so much focus has been on Howey, and understandably, and again, sometimes there's focus on Reeves, and then a lot of the other types of securities just don't get as much attention. And I do think that, who knows how things play out, but there could be some potential at some point in the future when someone says, hey, well, wait a minute, okay, well, Howey is that and Reeves is that, but turns out it's a pretty long definition. So where does all the other stuff situate itself? So in that kind of broad point around clarity, as well as workable substantive rules, regulations that advance across the breadth of the SEC's mission, to your point, there's a lot more in the definition of security than Howey and investment contracts, Reeves, notes, and it's a good reminder, I think. Chris.
So I'm going to sabotage that a little bit, but I will gesture towards notes and Reeves, and I think that there's a general consensus that Reeves is even less predictable than Howey is in terms of a sort of, in order to sort of set expectations as to whether or not securities law is applicable. But Teresa's statement actually reminded me of just one little, because I know we were asked to be auto mechanics, so just one little interesting question, because the capital formation process was brought up, which is when exactly, even under Howey, does the capital formation process end, particularly in the initial raise? Because often you have, equity warrants in a grant, you have token minting, listing agreement with an exchange. Well, whether or not capital formation ends or continues post-minting, and whether or not the initial token sale is ultimately facilitated by the listing, right? Some kind of guidance as to whether or not listing is the final step in monetizing tokens, because if it is in that direction, then it could be treated as part of the offering, and you could have very interesting things popping up, like listing agreements comprising part of the offering and the like. So that's an interesting and probably very practical task to clarify. Thanks.
Miles.
Yeah, so I would just say that I think going back to the kind of the control discussion that I've raised and several of the people have talked about, I think that is the overarching premise that would allow you to create a uniform and unifying principle across these regulatory regimes, right? Reeves is implicated, as Collins was just saying, if I deposit a token into a smart contract and then someone takes that and it issues me a stable coin back, and someone goes out and takes that token and tries to make money on it and then delivers those proceeds to me, that looks a lot like Reeves. If there's no one behind the smart contract and it's not controlled by anyone, then it's just fully autonomous, and the trust dependencies that get at the point of Reeves are no longer there. The same thing applies to profits interest. How can you have a profits interest in a smart contract, a piece of autonomous software that's not controlled by anyone, as compared to what the purpose of that regulatory regime is looking at profits interest in business entities. So as a result of that, right, I think control is the unifying principle that basically can be used to go across all of these different regulatory approaches. And I think that that's very important, right, because we need to have consistency in how we're thinking about the problems and where the risks arise.
Great. Thanks, Miles. So I think we're at time. I know there's going to be a few closing remarks. I thought the discussion was amazing among the panelists. I think encouraging that there's so many folks who are thinking so much about this question. I think it speaks to the stakes. I think it speaks to their own commitment to try to think all this through. I think it's safe to say there's no single way to approach this. I think that makes certainly interesting, makes it challenging for the commission, but I think that the commission is going to be much better able to land where it's looking to land with the benefit of input like this. Whether folks end up agreeing or disagreeing with how things play out, that's the natural part of the process, but the engagement, I think, is certainly encouraging, and hopefully that the task force found the conversation to be useful. So with that.
This is so fun, isn't it? What a cool day. So we're almost at 5 o'clock on a Friday evening. So where else in the world would you want to be than here? You guys might want to think about the life choices that got you here. So 6 months ago, I could not have fathomed a day like today would have happened, and I'm so excited to be here, to be working on these issues with the folks at the SEC and the folks from the public that have given it so much thought. Many have long asked for a regulatory framework for crypto, one that's workable, and now we have the opportunity to be part of constructing that. This is really exciting, but it's also a tremendous responsibility. Every single member of the Crypto Task Force understands the gravity of this responsibility. And so this effort today, trying to engage with the public in a meaningful way to have substantively meaningful conversations, is a part of that effort. We hope you continue to follow along. We are going to have 4 more roundtables that are focused on key issues in this area. We have also stood up a website that seeks input from you guys. You may have seen the written input page. I've heard that some people are stalking it, and it's really exciting, and WhatsApp messages are flowing because of it. So please continue to look at that page. There's a lot of really amazing scholarship on there, a lot of really great ideas. We're looking at them very closely, but we also hope that you'll contribute to it. If you've been thinking about these issues, we really welcome your thoughts on that. We also urge you to look again at Commissioner Peirce's February 21 statement, in which we outlined key questions that we're considering. That is also part of our process in getting the right input to make a strong framework for us. So that's it for us. I want you to enjoy the rest of your day and enjoy your weekend. And thank you to everyone on this panel and everyone in this building that helped make this possible.